Hello guys! Tonight, we're going to discover one of the most bizarre and fascinating stories in human justice. Courtrooms where pigs, rats, and even locusts were tried for crimes. That's right, animals in the defendant's dock with lawyers, judges, and real sentences. And the most incredible part, this happened for centuries throughout Europe. It's worth staying until the end because you'll discover not only the most absurd cases, but also what these stories reveal about how humanity has always tried to make sense of the chaos of the world. So get comfortable, turn off the lights if you want, and let's go. When a pig was sentenced to death, France, year 1386. The city of Falaise is about to witness something extraordinary. A trial is about to take place, but the defendant is not a thief, a human murderer, or a traitor. It's a sow. Yes, you heard that right. A common sow is being taken to court, accused of murder. The victim was a small child and the evidence was clear. The sow had attacked and killed the baby while it slept in its cradle. The tragedy devastated the family and shocked the entire community. But here's what makes this truly extraordinary. Instead of simply slaughtering the animal, the authorities decided it needed to be tried formally, with all the legal apparatus that a human being would be entitled to. And we're not talking about a symbolic ritual. Historical records show that the sow of Falaise was entitled to a defense attorney appointed by the court. A prosecutor presented the charges. Witnesses were heard. The judge conducted the proceedings strictly following the legal procedures of the time. Imagine the scene, a medieval courtroom, cold stone walls, torches lighting the space, and there, in the center of it all, a confused sow being tried for a crime she certainly didn't understand she had committed. The defense attorney built his arguments. The animal didn't possess reason, therefore couldn't have criminal intent. It acted on instinct, not malice. Punishing a being for its nature would be unjust. The prosecutor was relentless. The law was clear. An animal that takes a human life must be punished. There were precedents, and, most importantly, the community demanded justice. An innocent child had died and something needed to be done to restore order. After days of trial, the verdict came, guilty. The sentence, death by hanging. But here's where the story gets even stranger. The sow wasn't simply executed like any animal. She was dressed in human clothes, pants, shirt, even gloves on her front hooves. And she was publicly hanged in the town square before a crowd that watched as if it were the execution of a human criminal. Documents from the time meticulously record the costs: the attorney, the court, the executioner, even the clothes used in the execution. The sow's owner had to pay for everything. Or, can you imagine being the attorney assigned to defend a sow? You studied law, you know the laws, and now you need to build a defense for a client who can't speak, who doesn't understand the concept of crime, who doesn't even know she's being tried. And this wasn't an isolated case. Historical records reveal hundreds of animal trials throughout medieval and early modern Europe. Pigs, horses, cows, dogs, roosters, and not just large animals, also rats, locusts, slugs, caterpillars. The burning question is, why? What led entire societies to believe that an animal could be criminally responsible for its actions? The answer lies in how people of that era saw the world. There was a deep belief that all living beings were part of a divine order that needed to be maintained. If an animal broke this order by committing a violent act, it needed to be punished to restore balance. The Bible reinforced this view. In the book of Exodus, it's written, "If an ox gores a man or a woman to death, the ox shall be stoned." For many people, trying and executing animals wasn't absurd. It was following divine law. But there was also a powerful psychological element. Medieval life was harsh, unpredictable, full of inexplicable dangers, diseases, plagues destroying crops, animals attacking without warning. Trying these animals was a way of attempting to impose control over the uncontrollable. Think about it. If your entire harvest was destroyed by locusts, you'd feel powerless, at the mercy of forces you can't fight. But if you could take those locusts to trial, formally summon them, excommunicate them, suddenly you regain a sense of control. It's like saying, we, humans, are the masters of this world, and even you, tiny creatures, will answer before our justice. Curious how this resembles the way we today look for someone to blame when something bad happens, right? It's an ancient human need to transform chaos into something understandable, even if the logic is questionable. If you're enjoying our stories, subscribe to the channel to help our community grow and receive notifications of new stories. Comment where you're watching from and what time it is. It's fascinating for us to know where our community is around the world. The trials weren't cheap. Conducting a formal process cost real money: judges, attorneys, court officials, executioners. In the case of executions, there was the cost of the gallows, sometimes the clothes for the animal. Usually the animal's owner or the local community paid for everything. This means these weren't decisions made lightly. If a community decided to bring an animal to trial, it was because they really believed it was necessary, that it was worth the investment. And there was a logic to this, however strange it seems to us. These trials weren't just about the animal, they were about the community, about giving people a sense that justice was being done, that the world still made sense, that there was order, even in the face of tragedy. The parents of the child killed by this sow in Falaise were devastated, and they wanted justice. They wanted someone to pay for what had happened. And the society of the time offered that through the trial of the animal. When something terrible happens, especially something that seems random and meaningless, we humans desperately search for meaning, for reason, for someone or something to hold accountable. Today we usually seek to hold other humans accountable: the manufacturer of a defective product, the doctor who made a mistake, the driver who caused an accident. But the impulse is the same: to transform chaos into order. And there's another fascinating detail. In many cases, it wasn't just the animal that was held accountable. The owner could also be punished, especially if there was evidence of negligence. If the animal had a history of violent behavior and the owner didn't take adequate precautions, they also faced legal consequences. This shows that even within this strange framework, there was a recognition of human responsibility. It wasn't just, the animal is evil, let's punish it. There was an understanding that humans had a duty to control and supervise their animals. The dangers were real. Domestic animals lived in much closer proximity to humans than they do today. Pigs often roamed freely through the streets of medieval cities, feeding on garbage. It wasn't uncommon for them to attack small children left unsupervised. There were no vaccines against rabies. A dog attack could be fatal not just from the initial injury, but from the infection that followed. If the dog had rabies, the victim faced a horrible and inevitable death. So, when an animal attacked, it was a real and serious threat to the life and safety of the community. And the community needed a way to deal with it, to process the trauma, to feel safe again. The trials offered exactly that. But the case of the sow of Falaise is just the tip of the iceberg. Because if you think trying an individual pig is strange, the story gets even more fascinating when we discover trials of entire populations of animals. In 1522, in the French city of Autun, something extraordinary happened. The region was being devastated by a plague of rats destroying the crops. And the community decided to do something about it: sue the rats. All of them. An attorney named Bartholomew Chassenet was appointed to defend the rats, and he took it so seriously that he built such a brilliant defense that he gained fame and significantly advanced his legal career. When the rats didn't appear in court after being summoned, and yes, there were formal summonses read aloud in the fields, Chassanet argued that the summons was invalid because it hadn't been delivered to all the rats individually. How could you guarantee that all the rats in the region had been adequately notified? Furthermore, he argued that the rats had legitimate fear of travelling to the court because they would have to pass through areas inhabited by cats, their natural predators. The court had an obligation to guarantee safe passage for the defendants, and failing to do so violated the rats' rights to a fair trial. Think about the brilliance of these arguments. He was using the system's own logic against itself. If you're going to treat the rats as defendants with legal rights, then you have to actually respect those rights. The court was so impressed that the case was postponed several times while they tried to resolve these procedural issues. Eventually, the case seems to have been abandoned, possibly because the rat plague ended naturally while the court debated the legal details. And here's something curious. Sometimes the sentences really seem to work. Not because the animals understood or obeyed the court order, but because insect plagues are naturally temporary. They come, devastate an area, and then move on or die due to climate changes or lack of food. So, if you held a trial and issued a banishment order, and a few weeks later the insects actually left, it reinforced the belief that the system worked, a kind of medieval confirmation bias. But there were even stranger cases. In 1474, in the Swiss city of Basel, a rooster was tried and executed. His crime? Laying an egg. Biologically impossible, of course. But at the time it was believed that when a rooster laid an egg, it was a sign of witchcraft or demonic intervention. And from a rooster's egg, according to superstition, a basilisk would be born, a legendary creature whose gaze could kill. The rooster was found guilty of unnatural practices and of being an agent of the devil. It was burned alive along with the egg it had supposedly laid. These cases reveal something profound about the mentality of the time. They weren't just about punishing animals for practical damage. They were about maintaining cosmic order, about fighting what was seen as unnatural or demonic, about giving people a sense of control in a world full of mysteries and dangers. And here's a question worth reflecting on. What will our current practices say about us 500 years from now? What things that we consider perfectly normal and rational today will be seen as absurd by future generations? The people who tried pigs and rats weren't stupid. They were intelligent, careful, serious. They were working within a framework of understanding the world that made sense to them based on the best information and beliefs they had available. We're doing the same. And some of our decisions inevitably will seem as strange to our descendants as animal trials seem to us. But the story of animal trials is just beginning, because when you dive deeper, you discover that there was an entire jurisprudence developed around this. There were precedents being cited, theological and legal debates, different schools of thought about how these cases should be conducted, and some of the most fascinating cases involved not individual animals, but entire populations. And it was in these cases that human legal creativity was really tested to the limit. Because how do you summon thousands of insects? How do you ensure they've all been adequately notified? And what do you do when, inevitably, they don't show up in court? The answers to these questions reveal something profound about how humans think, about how we try to impose order on chaos, and about how far human creativity can go when we face the impossible. So we just saw how individual animals were tried, pigs, roosters, dogs. But now we're entering even more fascinating territory. Trials of entire populations of animals. And this is where medieval legal creativity was really tested to the extreme. When thousands of insects were summoned, imagine the following situation. You're a farmer in 15th century France. You planted your crop, cared for it for months, and now you're about to harvest. Your survival through the winter depends on it. Your family's survival depends on it. And then suddenly a plague of locusts appears. In a matter of days, they devastate everything. Months of work destroyed. Your food security vanished, and you have no way to fight it. There are millions of insects, impossible to control. The desperation is total, and in this desperation, communities sought any possible solution, including taking the insects to trial. Historical records show that between the 13th and 17th centuries, dozens of legal proceedings were filed against insects throughout Europe. Locusts, caterpillars, beetles, even snails and slugs. Any creature that threatened crops could end up in court. But how do you sue millions of insects? How do you summon creatures that don't understand human language, that can't appear in court, that don't even know that they're being sued? Well, medieval authorities developed specific procedures for this, and they were surprisingly elaborate. First, the affected community needed to present a formal petition to the ecclesiastical court. Yes, it was the church courts that usually handled these cases, not civil courts. Why? Because it was believed that insect plagues were ultimately a spiritual matter, possibly divine punishment, or the work of demonic forces. The petition described the damage caused by the insects, the impact on the community, and requested that the court take action. If the court accepted the case, the next step was to summon the insects. And here's where it gets interesting. A court official would literally go to the fields where the insects were and read the summons aloud. The summons was formal, following all legal protocols. It identified the defendants, the insects, described the charges, and ordered them to appear in court on a specific date. Think about the scene. A court official, formally dressed, standing in a field, devastated by locusts, solemnly reading a legal document to thousands of insects that obviously aren't paying attention. It's absurd, right? But within the logic of the time, it made sense. If you're going to sue the insects, you need to follow proper procedures. And proper procedure requires that the defendants be formally notified of the charges against them. Obviously, the insects didn't appear in court. But this wasn't a problem because the court appointed an attorney to represent them. And these attorneys took their work very seriously. Can you imagine studying law for years, building a career, and then being assigned to defend locusts? But these attorneys didn't treat it as a joke. They built elaborate defenses, cited legal precedents and religious texts, and argued passionately for their clients' rights. One of the most common arguments was that the insects had a divine right to exist and to feed themselves. God had created all creatures and each had its place in creation. The insects were merely following the instincts God had given them. Expelling or punishing them would be going against divine will. Another argument was that the insect plague was in fact God's punishment against the community for their sins. If it was divine punishment, then humans had no right to interfere. Instead of suing the insects, the community should do penance and seek God's forgiveness. The prosecutors in turn argued that God had given humans dominion over animals, as established in Genesis. This dominion included the right to protect their crops and their lives. The insects were abusing their place in the natural order by causing excessive destruction. They also argued that even if the plague was divine punishment, that didn't mean humans should accept it passively. God also expected humans to take practical measures to protect themselves. These debates could last weeks, sometimes months. Witnesses were called to describe the extent of the damage. Experts, usually priests or scholars, were consulted on theological questions. Precedents from previous cases were cited and debated, and then finally came the moment of sentencing. The sentences varied greatly. In some cases, the insects were excommunicated, expelled from the church community. The idea was that without the church's spiritual protection, the insects would be forced to leave or would die. In other cases, the insects were formally banished from the region. A decree was issued ordering them to leave within a specific time frame, usually a few days or weeks. The decree was read aloud in the fields, just as the original summons had been. Sometimes the sentence was more creative. In some cases, the court designated a specific area where the insects could live and feed, a kind of reserve for insects. The decree ordered the insects to move to this area and stay there, away from human crops. Think about the logic of this. The court was essentially trying to negotiate with the insects, offering them a compromise. You can live, but not here. Go to that place over there. And you know what's most fascinating? Sometimes this really seemed to work. Not because the insects understood or obeyed the order, of course, but because insect plagues are natural phenomena with predictable cycles. They appear, feed, reproduce, and then move to another area or die due to climate changes, lack of food, or natural predators. So if you held a trial that lasted a few weeks, issued a banishment sentence, and then, by pure coincidence, the plague ended naturally soon after, well, that seemed to confirm that the system worked. It was a perfect example of confirmation bias. People remembered the cases where the plague ended after the trial and forgot or rationalized the cases where nothing changed. But there were also cases where the sentence was different. Sometimes the court decided that the fault wasn't with the insects but with the community itself. In 1516, in the region of Villeneuve, France, there was a trial against caterpillars that were destroying the vineyards. The defense attorney for the caterpillars argued brilliantly that the creatures were merely following their nature and that the true cause of the problem was the sin and immorality of the community. And the court agreed. The sentence ordered the community to do penance, participate in religious processions, and correct their sinful behaviors. Only then, the court argued, would God remove the plague. Is that so different from how some people today interpret natural disasters? How many times have we heard someone say that a hurricane or earthquake is divine punishment for behaviors they disapprove of? But getting back to the trials, there were even more complex cases. Sometimes the insects won the case completely. In 1545, in Saint-Julien, France, there was a trial against beetles that were destroying the vineyards. The case dragged on for months. The defense attorney for the beetles built such convincing arguments that the court was divided. Eventually, the parties reached an agreement. The community agreed to designate a specific area of land for the beetles, with good vegetation and water. In exchange, the beetles, theoretically, would leave the vineyards alone. A formal document was drafted describing the terms of the agreement. It was signed by the community representatives and the beetles' attorney, and it was officially recorded in the court archives. Yes, you read that right. A legal contract between humans and beetles. The designated area was even marked with crosses and religious symbols, and a priest went there to bless it, officially making it the beetles' territory. Now, we can laugh at this today, but think about what this reveals about the mentality of the time. There was a genuine belief that the natural world could be influenced through legal procedures and religious rituals, that words had power, that formalities mattered, that order could be imposed on chaos through structure and ritual, and there's something almost touching about it, isn't there? Desperate people, facing forces they couldn't control, using the only tools they had, law and religion, to try to protect their families and communities. They were wrong about how the world works, of course. But the impulse was deeply human, to do something, anything, rather than passively accept disaster. There were also cases involving aquatic animals. In 1587, in Lausanne, Switzerland, there was a trial against leeches that infested a local lake. The leeches were a serious problem. They attacked people and animals that entered the water and made the lake practically unusable. The community sued the leeches in ecclesiastical court. An attorney was appointed to defend them. The case followed all formal procedures. Summons read at the lakeshore, arguments presented, witnesses heard. The sentence was excommunication. The leeches were formally expelled from the church community and ordered to leave the lake. A priest went to the lake shore and read the sentence aloud, making the sign of the cross over the waters. And then, eventually the leeches decreased in number, probably for completely natural reasons unrelated to the trial, but for the community it was proof that the system worked. These trials of animal populations reveal something fascinating about how humans deal with threats beyond their control. When you can't solve a problem through direct practical means, you create elaborate structures, legal, religious, ritual, that at least give the illusion of control. And this illusion isn't useless. It serves important psychological and social purposes. It unites the community around a common goal. It provides a narrative that makes sense of chaos. It offers hope that something can be done. We still do this today, in different ways. When we face complex problems that seem unsolvable, climate change, pandemics, economic crises, we create elaborate structures, hold conferences, sign agreements, create legislation. Sometimes these actions have real practical effects. Sometimes they're more symbolic than effective, but they serve the purpose of making us feel we're doing something, that we have some control. But there was one aspect of these insect trials we haven't fully explored yet: the role of defense attorneys. These men, and they were all men at the time, were trained lawyers, many of them quite respected. And they took their responsibility to defend the insects very seriously. Why? Part of it was professionalism. If you're a lawyer, your job is to defend your client to the best of your ability, no matter who or what that client is. But there was also a matter of principle. These attorneys genuinely believed that all beings created by God had rights, even if they were limited rights, and that the legal system should respect those rights. Some of the arguments they built were genuinely brilliant. They explored contradictions in the prosecution's logic. They found obscure precedents that supported their position. They asked difficult questions that the court had to answer. For example, if God created the insects and gave them the instinct to eat plants, how can you punish them for following the nature God gave them? Wouldn't that be questioning God's wisdom? Or if the Bible says that God cares even for the sparrows and that not one of them falls without his knowledge, how can you argue that God doesn't care about the fate of insects? These were genuine theological questions, and the courts had to take them seriously. And here's something worth reflecting on. These attorneys defending insects in medieval courts were, in a way, doing something that still struggles to be accepted today, arguing that non-human beings have rights that should be respected. Today we have debates about animal rights, about whether great apes or dolphins or elephants should have some form of legal personhood. Some countries have already recognized rivers as having legal rights. It's a concept that's still evolving. But these medieval attorneys within their own belief framework were already exploring these ideas 500 years ago. Of course, they were doing it for different reasons than ours. They weren't concerned with animal suffering or ecology. They were concerned with divine order and proper legal procedure. But still, it's fascinating to see these connections across time. The trials of animal populations also reveal something about the relationship between law and religion in medieval times. These two systems were deeply intertwined, almost inseparable. Law wasn't seen as something purely human, created by humans to serve human purposes. It was seen as a reflection of divine law, of the order God had established for the universe. So when you tried insects, you weren't just trying to solve a practical problem. You were trying to align the earthly world with the celestial order. You were trying to understand and apply God's will. This made these trials much more serious than they might seem to us today. They weren't just about crops and insects. They were about the very structure of reality, about humanity's place in the cosmos, about how to maintain balance between the natural world and the human world. And when the trial ended, when the sentence was pronounced and executed, There was a sense that something important had been accomplished, not just practically, but spiritually. Order had been reaffirmed. Chaos had been confronted. The community had united and taken a stand. Even if the insects didn't leave immediately, even if the plague continued for a while, the very act of holding the trial had value. It said, we don't accept this passively, we have agency. We have structures and systems that allow us to respond even to what seems impossible to control. And maybe that's what these bizarre trials really teach us. Not that people of the past were naive or foolish, but that humans have always found ways to confront the uncontrollable, to impose meaning on chaos, to create order through ritual and structure. We still do this, we've just changed the forms. But animal trials weren't all about insects and plagues. There were also cases involving property issues, civil liability, disputes between neighbors. And these cases reveal yet another fascinating aspect of this strange practice, how it intertwined with the social and economic structures of the time. So far, we've seen trials motivated by tragedies, dead children, destroyed crops. But not all cases were so dramatic. Some animal trials involved more mundane matters, property disputes, material damages, conflicts between neighbors. And these cases reveal something fascinating about how medieval law worked in everyday life. When animals became disputed property in 1499 in the Burgundy region of France, there was a peculiar case involving a bull. The animal had escaped from its property and caused significant damage to the neighboring farm, destroyed fences, trampled a vegetable garden, and frightened the neighbor's cattle. The owner of the damaged property sued not only the bull's owner, but the bull itself. He argued that the animal had committed property invasion and intentional destruction of goods, and he demanded that the bull be punished and that the owner pay compensation. The bull's owner defended himself by arguing that the animal had escaped accidentally, that there was no malicious intent, and that he himself was a victim. After all, he had lost his valuable bull. He even suggested that perhaps the neighbor's fence was poorly built, facilitating the animal's escape. The case was taken seriously by the court. Witnesses were called to examine the fences of both properties. Cattle experts were consulted about typical bull behavior. Legal precedents were cited about animal owners' liability. Eventually, the court decided that both parties were partially at fault. The bull was declared guilty of invasion and destruction, but the bull's owner was considered negligent for not maintaining adequate fences. The sentence ordered the owner to pay compensation to the neighbor and that the bull be sold, with part of the profits going to cover the damages. Cases like this were surprisingly common. They show that animal trials weren't just about spiritual or cosmic matters. They were also practical tools for resolving everyday disputes in communities where animals and humans lived in much closer proximity than today. Think about the situation. You're a medieval farmer. You don't have insurance. You don't have a modern legal system with detailed civil codes. But you have a system that allows you to sue not only your negligent neighbor, but also the animal that caused the damage. This offers multiple avenues for seeking compensation and justice. And there was an economic logic to this. Animals were valuable property. A bull, a horse, even a pig represented significant investment. If the animal caused damage, it itself could be used to compensate for that damage through sale, confiscation, or execution. But it wasn't always about money. Sometimes it was about principles, about honor, about social status. In 1471 in Basel, Switzerland, there was a case involving a rooster that belonged to a wealthy merchant. The rooster had a habit of crowing very early in the morning, waking up the neighbors. One of the neighbors, a lower-class artisan, sued the rooster for disturbing the peace. The case quickly became about more than just a noisy rooster. It became about class tensions, about the right of wealthy people to bother their poorer neighbors, about who had more power in the community. The wealthy merchant argued that roosters naturally crow at dawn, that this is normal and expected behavior, and that suing a rooster for crowing was absurd. He also insinuated that the artisan was just trying to cause trouble for someone of superior status. The artisan argued that the rooster crowed excessively, much earlier and louder than normal roosters, and that this was affecting his health and his ability to work. He cited laws about disturbing the peace and argued that no one, rich or poor, had the right to deprive others of sleep. Can you see how familiar this is? Disputes between neighbors about noise, about property boundaries, about who has what rights. The legal tools were different, but the basic human conflicts were the same. The court eventually decided in favor of the artisan, but with a creative solution. The rooster wouldn't be executed or removed. Instead, the merchant was ordered to keep the rooster in a covered coop during the night, which would muffle the sound in the morning. If the rooster continued to disturb the neighbors, then more severe measures would be considered. It was a pragmatic solution that tried to balance the rights of both parties. And it shows that medieval courts, despite all the strangeness of trying animals, were still trying to do what courts always try to do: find fair solutions to human conflicts. And you, what do you think about this? Leave your opinion in the comments. There were also cases involving working animals: horses, oxen, mules, animals that were essential to the medieval economy. And when these animals caused problems, the consequences could be serious. In 1389, in Dijon, France, a horse kicked and killed its handler. The horse belonged to a local nobleman, and the handler was a serf. The case was complicated by issues of class and property. The dead handler's family demanded justice. They wanted the horse executed, as would happen with any murderer. But the nobleman argued that the horse was valuable property, that the handler had probably provoked the animal, and that executing the horse would be an unjust economic loss. The court had to balance several considerations: justice for the victim's family, the nobleman's property rights, legal precedents about animals that kill humans, and the economic realities of the situation. The final decision was a compromise. The horse was declared guilty of homicide, but instead of execution, it was ordered that the nobleman pay substantial compensation to the handler's family, and that the horse be sold, with the profits also going to the family. Additionally, the horse was branded, literally branded with hot iron, to permanently identify it as a dangerous animal. This brand served multiple purposes. It was physical punishment for the animal. It was a warning to future owners and handlers. And it was a permanent, visible record of the trial and sentence. Cases like this show how animal trials intertwined with the complex social and economic structures of the time. They weren't just about the animal, they were about power relations, about property, about class, about how different groups in society interacted and came into conflict. And there were cases involving multiple animals and multiple parties. In 1474, in Bern, Switzerland, there was an extraordinarily complex case involving a pack of dogs that had attacked and killed sheep belonging to several different farmers. The dogs belonged to different owners, the sheep belonged to different farmers, and there were disputes about which dogs exactly had participated in the attack, who was responsible for how much damage, and how compensation should be distributed. The case took months to resolve. Witnesses were interrogated extensively. Experts tried to determine, based on the wounds on the sheep, how many dogs had participated and what breed they were. The dog owners tried to prove that their specific animals weren't present at the attack. Eventually, the court determined that 3 of the dogs were definitely guilty, 2 were probably guilty, and the others were innocent for lack of evidence. The 3 definitely guilty dogs were executed. The 2 probably guilty ones were punished with public whippings. Yes, the dogs were publicly whipped as punishment, and their owners were fined. The owners of the innocent dogs were acquitted. Compensation was calculated meticulously based on the value of each dead sheep and the degree of culpability of each dog and owner. It was a complex exercise in distributive justice, trying to balance multiple interests and ensure that each party received what was due. Think about the amount of work this involved: months of court time, dozens of witnesses, elaborate calculations of compensation, all of this to resolve a dispute about dogs and sheep. But for the people involved, this wasn't trivial. Those sheep represented wealth, food security, survival. Losing several sheep could mean the difference between getting through winter comfortably or starving. So, seeking justice through the legal system, even if that system included trying the dogs themselves, made perfect sense. There were also cases involving wild animals. These were particularly interesting because they raised questions about who was responsible for animals that had no owner. In 1519, in a rural region of France, a wild bear had attacked and killed a shepherd. The local community wanted justice, but how do you sue a wild bear? Who is the defendant? Who pays compensation? The solution was to prosecute the bear as if it were a human criminal without property or family. The bear was hunted, captured, and brought to trial. It was kept in a cage during the proceedings, and an attorney was appointed to defend it. The defense attorney argued that the bear was a wild animal acting according to its nature, that it had no knowledge of human laws, and that executing it would be unjust. He also argued that humans had invaded the bear's natural territory, and that the bear was merely defending itself. The prosecutor argued that regardless of being wild or domestic, any animal that kills a human must be punished. He cited biblical and legal precedents, and he argued that allowing the bear to live would send a dangerous message that animals could kill humans without consequences. The bear was found guilty and executed, but the case established an interesting precedent. Wild animals could be tried and punished, even without a human owner to hold accountable. This raises fascinating philosophical questions. If a wild animal has no owner, wasn't raised or trained by humans, is just following its natural instincts in its own habitat, is it fair to hold it accountable for its actions? Is it fair to punish it? For us today, the answer seems obvious. No, it doesn't make sense to try a wild bear. But for people of the time, within their belief framework about divine order and cosmic justice, it made sense. The bear had broken the order by killing a human. This breach needed to be corrected through trial and punishment. And there's something more in these cases involving wild animals. They reveal tensions about territory and resources. As human populations grew and expanded, they increasingly came into conflict with wild animals. Forests were cut down, lands were cultivated, and the natural habitats of animals shrank. The animals naturally sometimes reacted, attacking livestock, destroying crops, occasionally attacking humans. And humans, in turn, used the tools they had, including the legal system, to deal with these conflicts. Trying and executing wild animals was, in part, a way of asserting human dominion over territory. It was saying, "This land is ours now, human rules apply here. Even you, wild creatures, must submit to our justice." Is it so different from how we deal with conflicts between humans and wildlife today? When a bear or lion enters an inhabited area and attacks someone, we usually hunt it down and kill it. We don't formally try it, but the end result is the same. And the underlying logic, protecting humans, asserting control over territory, is also similar. But getting back to medieval trials, there was one type of case that was particularly complex. Cases involving animals that belonged to the church. The medieval church was one of the largest landowners and animal owners. Monasteries and convents maintained large herds and farms. And when these animals caused problems, the question arose, how do you sue an animal that belongs to the church? In 1494, in a region of Italy, a bull belonging to a monastery escaped and caused significant damage to neighboring farms. The farmers wanted compensation, but suing the church was complicated. The church had special legal privileges, immunities that others didn't have. The case was eventually resolved through negotiation. The monastery agreed to pay compensation, but insisted that the bull not be tried or punished, arguing that church animals were under special divine protection. This solution dissatisfied many, but it illustrates how animal trials existed within broader power structures. Not all animals were equal before the law. Animals belonging to nobles or the church often received more favorable treatment than animals belonging to common people. This reminds us that justice, in any era, is never completely blind. It's always influenced by power, wealth, and social status. Medieval animal trials, however strange they seem, reflected the same inequalities and tensions that any legal system reflects. And there were cases that were genuinely tragic. In 1457 in Lavigny, France, there was the case we mentioned before, a sow and her 6 piglets accused of killing a child. The sow was executed, but the piglets were acquitted. What makes this particularly touching is that the records show there was genuine debate in the court about the fate of the piglets. Some argued that all animals present should be executed. Others argued that the piglets were too young to have participated in the attack, and that executing them would be unjust. The court finally decided on acquittal, but with conditions. The piglets were returned to the owner, but with the warning that if they showed any sign of aggression in the future, they would be immediately executed without a new trial. There's something deeply human in this debate. Even within a system that seems absurd to us, trying animals for crimes, there were people trying to be fair, trying to distinguish between guilty and innocent, trying not to punish the young for the acts of their parents. They were applying principles of justice that we recognize: presumption of innocence, need for evidence, proportionality of punishment. They were just applying these principles to piglets. And that's perhaps the most important lesson from these everyday cases of animal trials. They show that however strange the practice was, the people involved were genuinely trying to do justice. They were using the tools and structures they had available to resolve conflicts, protect their communities, and maintain some sense of order in a frequently chaotic and dangerous world. We can laugh at the idea of trying a rooster for crowing or a bull for trespassing, but the underlying human needs, resolving disputes, seeking compensation for damages, maintaining peace in the community, are the same ones that motivate our legal systems today. We've just changed the methods. But the fundamental challenges of living in community, of balancing rights and responsibilities, of seeking justice in an imperfect world, these remain the same across the centuries. And as we explore these trials more deeply, we begin to see that they weren't just about animals. They were about us, about how humans try to create order, about how we deal with conflict and tragedy, about how our beliefs shape our institutions. But there's still another aspect of these trials we need to explore: the role of public executions. Because when an animal was sentenced to death, the execution wasn't a private event. It was a public spectacle, carefully orchestrated, loaded with symbolic meaning. And these spectacles reveal something profound about medieval society and about human nature in general. When an animal was sentenced to death in medieval Europe, what happened next wasn't simply an execution. It was a carefully choreographed public ritual loaded with symbolism designed to send specific messages to the community. And these rituals reveal as much about the people who performed them as about the animals that were executed. The theatre of public justice lets go back to that sow in Falaise in 1386. We already know she was sentenced to death for killing a child, but the details of her execution tell a deeper story about what these ceremonies really meant. The execution was scheduled for a specific date with enough advance notice for the news to spread throughout the region. It wasn't something done hastily or in secret. It was an event that the entire community was expected and even encouraged to witness. On the appointed day, the sow was brought from the prison where she had been kept during the trial. And here's a fascinating detail. She was dressed in human clothes, not simple clothes, but clothes that imitated what a human criminal would wear for execution. Pants, a shirt, gloves on the front hooves, even a mask or hood in some accounts. Why do this? Why dress an animal in human clothes before executing it? The answer lies in what the execution was trying to communicate. By dressing the sow as a human, the authorities were making a statement. This animal is being treated as a being responsible for its actions. It's not just an animal being slaughtered, it's a criminal being punished. The sow was then led through the streets to the public square where the gallows had been erected. And this procession wasn't quick or discreet, it was slow, deliberate, allowing everyone to see the condemned animal being led to its fate. Think about the scene, the narrow streets of a medieval town, people crowding at windows, in doorways along the route, children being lifted by parents for a better view. Quiet conversations, perhaps some people making the sign of the cross, others simply watching in silence, and in the center of it all, a sow dressed in absurd human clothes, being led by serious officials toward her death. When the procession reached the square, the crowd was already gathered. Public executions were important social events in medieval times, not just because they were entertainment, although there was certainly an element of that, but because they served important social and educational functions. The sow was led to the scaffold. The executioner, who had been paid specifically for this job, prepared the rope. And then, before the execution itself, there was often a public reading of the sentence. A court official read aloud the animal's crimes, the verdict, and the justification for the punishment. This wasn't just formality, it was public education. It was the legal system explaining itself to the community, demonstrating that justice was being done according to proper procedures, and then finally, the execution. The sow was hanged exactly as a human criminal would be hanged. The method was the same, the ritual was the same, even the time it took for the animal to die was similar.
Can you imagine watching this, not as a distant or abstract spectacle, but as something real happening right in front of you? The animal struggling, the sound, the smell, and around you, your entire community witnessing it together. After the sow was dead, her body wasn't simply removed and discarded. In many cases, the body was left hanging for a period as a warning. In some cases, it was buried in unconsecrated ground, as would happen with a human criminal. In other cases, it was burned.
Each of these post-execution treatments carried meaning. Leaving the body hanging was a continuous visual warning. Burial in unconsecrated ground denied the animal any religious blessing. Burning the body was seen as purification, removing the contamination that the crime had brought. And the costs of all this, building the gallows, paying the executioner, the clothes for the animal, even the removal and disposal of the body, were meticulously documented and charged, usually to the animal's owner. But the execution of the sow of Falaise wasn't unique. There were established patterns for how different animals should be executed, based on precedents and practical considerations. Pigs and dogs that killed humans were generally hanged, like the sow of Falaise. Horses and bulls that killed were sometimes beheaded or killed with spears, methods that were more practical given the size of the animals. Smaller animals, like roosters accused of witchcraft, were burned alive. And each method carried its own connotations. Hanging was the standard punishment for murder. Burning was reserved for crimes related to heresy or witchcraft. Beheading was sometimes used for animals of greater value as a more honorable form of death. Yes, you read that right. There was a hierarchy even in animal executions reflecting the value and status of the animal and, by extension, of its owner. In 1474, when that rooster in Basel was condemned for supposedly laying an egg, his execution was particularly elaborate. He was burned alive in the public square, along with the egg. But before the burning, there was a ceremony where a priest read biblical passages about witchcraft and condemned the rooster as an agent of demonic forces. The crowd that watched wasn't just seeing a rooster being burned, they were participating in a purification ritual, in the expulsion of evil from the community. It was both religious and legal, both spiritual and practical, and people took it seriously. There are records of people making the sign of the cross as the rooster burned, of prayers being recited, of a sense that something important and necessary was being done. For us today, it seems absurd and even cruel. But for them, it was protection. It was the community defending itself against forces it didn't fully understand, but deeply feared. There were also cases where the execution was more private, but still ritualized. When animals of greater value, expensive horses, valuable breeding bulls, were condemned, there were sometimes negotiations to avoid public execution. In some cases, the animal was executed privately, but its hide or head was displayed publicly as proof that the sentence had been carried out. In other cases, the animal was permanently branded and sold far away, with the brand serving as a perpetual record of its crime. These variations show that even within this strange system, there was flexibility, there was negotiation, there were practical and economic considerations that tempered ideals of absolute justice. But perhaps the most elaborate rituals were those involving excommunication of insects. Remember the cases we discussed before where locusts or caterpillars were prosecuted? When these animals were condemned, the usual sentence was excommunication, and the excommunication ceremony was complex and formal. A priest, dressed in his full vestments, would go to the fields where the insects were. He was often accompanied by a procession, other clergy, court officials, community members. Arriving at the location, the priest performed a ritual that combined legal and religious elements. He read the court sentence aloud, then he read relevant biblical passages. He made the sign of the cross over the fields. Sometimes holy water was sprinkled, and then came the formal excommunication. The priest declared that the insects were expelled from the church community, that they no longer had the right to divine protection, that they were cursed and ordered to leave. In some cases, the ceremony included creating a symbolic barrier. Crosses planted around the fields, lines of salt or holy water marking boundaries that the insects should not cross. Think about the image of this. A priest in full vestments, standing in a field infested with locusts, solemnly performing an excommunication ritual for insects that obviously aren't paying attention. Around him, desperate farmers watching, waiting, praying for it to work. It's almost comical from a modern perspective, but it's also deeply human. It's people doing everything they can, using all the tools they have, law, religion, ritual, to protect their lives and their families. And sometimes, by pure coincidence or for unrelated natural reasons, the insects really did leave after these ceremonies. And when that happened, it reinforced the belief that the system worked, that the rituals had power. There were also executions that were deliberately designed to be educational. In some cases, after the execution of a pig for attacking a child, other pigs from the region were brought to see the body of the executed animal. The idea was that they would see what happened to their companion and learn the lesson. Of course, we know this is absurd. Pigs don't learn through examples of legal punishment. But the belief was genuine. And even if it didn't work the way people thought, these demonstrations still served a purpose. They reassured the community that measures were being taken, that authorities were protecting people, that there were consequences for dangerous animals. Public executions of animals also served to reinforce social hierarchies. The ability to condemn and execute an animal was a demonstration of power. It was the legal system controlled by elites, asserting its authority over all aspects of life, even over the animal world. And the community's participation in these executions wasn't passive. People were expected to witness, to approve, to participate in the collective ritual of punishment and purification. This created social cohesion, a sense of shared values, a reaffirmation that everyone was part of the same moral and legal order. But not all executions went smoothly. There are records of cases where the execution failed technically. The rope broke, the animal survived the first attempt, and this created dilemmas. Some saw a failed execution as a sign of divine intervention, as God demonstrating that the animal should be spared. Others saw it as simply a technical problem that needed to be corrected. These debates could lead to new trials, consultations with religious authorities, community discussions about the meaning of the failure. In one case, in 1499 in France, a condemned horse survived the first execution attempt when the rope broke. There was intense debate about whether this was a divine sign. Eventually, they decided it wasn't, and the horse was successfully executed on a second attempt. But the fact that there was debate shows that people took these signs seriously, and there were cases where the community was divided about the justice of the execution. When a valuable animal was condemned, especially if it belonged to someone poor who depended on it for survival, there could be public sympathy, pleas for clemency, even protests. These cases reveal tensions between different values: justice versus mercy, punishment versus economic considerations, the letter of the law versus individual circumstances. These are tensions we recognize because we still face them in our own legal systems. Public executions of animals also had an entertainment dimension we can't ignore. They were events that broke the monotony of everyday life, that offered spectacle and drama. People dressed up to attend, brought food, made it a social occasion. This may seem morbid to us, but it was part of the culture of the time. Public executions of humans or animals were one of the few forms of public entertainment available, and mixing the serious with the social, the ritual with the recreational, was perfectly normal. But beneath the entertainment, there was always the serious element. These executions were reminders that actions had consequences, that order must be maintained, that the community had standards and boundaries that would be enforced. And for the victims' families, the family of the child killed by the sow, the farmers whose crops were destroyed, these executions offered something important: closure, a sense that justice had been done, that their pain had been acknowledged, that the world had been somehow rebalanced. We can disagree with the methods. We can find the practice strange or even cruel. But the underlying human need to process trauma through ritual, to seek justice for harm suffered, to feel we live in an ordered world where actions have consequences, that need is universal and timeless. And maybe that's what public executions of animals really teach us. Not that people of the past were barbaric or irrational, but that humans have always created elaborate rituals to deal with chaos, tragedy, and the need for justice. We still do this. We've just changed the forms and targets, but there's still another aspect of these trials we need to explore. What happened when the sentences weren't death, but other forms of punishment? Because not every condemned animal was executed. There was a whole range of alternative punishments, each with its own meaning and purpose. And these alternatives reveal even more about how the system worked and what it was trying to achieve. Have you ever stopped to think about what it really means when someone invites you to dinner? On the surface, it's just a shared meal, but there are layers of social meaning. It's a gesture of friendship, of hospitality, sometimes of obligation. Refusing a dinner invitation can be offensive. Accepting creates a kind of social bond. Now multiply that dynamic by 100, add rigid social hierarchies, feudal obligations, public displays of power, and you begin to understand what a banquet was in the Middle Ages. Food wasn't just food, it was language, it was politics, it was theatre. And understanding this is crucial to comprehending why there was so much apparent waste, because much of what looked like excess was actually intentional communication. Let's start with the fundamental concept of medieval hospitality. In the Middle Ages, especially among the nobility, there was an absolute expectation that you would feed any visitor of appropriate status. Failing to do so was a grave dishonor, an insult that could generate lasting enmities or even armed conflicts. But it wasn't just about offering food. It was about offering abundant, varied, impressive food. A nobleman who served a simple meal to an important visitor was essentially saying, "You're not worth my best." It was an insult coded in food. On the other hand, an elaborate banquet said, "You are important, I have resources, I respect you enough to demonstrate my wealth in your honor." It was diplomacy through gastronomy, and this is where waste comes in. These banquets often featured far more food than guests could possibly consume. But this excess wasn't accidental. It was the central point. The message was, "I am so rich that I can afford to prepare more food than you can eat." Think about it. In a society where most people lived on the edge of subsistence, where hunger was a real and constant threat, demonstrating that you had surplus food was the ultimate display of power and security. Medieval banquets were carefully choreographed performances. They weren't just about eating, they were about seeing and being seen, about demonstrating status, about reinforcing social hierarchies. The seating arrangement was crucial. Whoever sat closest to the host had the most status. Whoever sat farthest had the least. The quality of food served varied according to one's position at the table. Those of high status received the best cuts of meat, the finest breads, the most expensive wines. Those of lower status received progressively lower quality food. But everyone received more than they could eat, because part of the point was that there would be leftovers. And these leftovers, as we discussed, followed their own redistribution hierarchy. Here's a fascinating detail. Guests at a medieval banquet often took leftovers home with them. It wasn't considered rude or greedy, it was expected. There were even servants specifically designated to package leftovers for guests to take. This served multiple purposes. First, it extended the host's generosity beyond the banquet itself. Second, it allowed guests to demonstrate the host's generosity to others. "Look at this fine meat I received at Lord So-and-so's banquet." Third, it ensured that less food was truly wasted. But there were rules. You couldn't just take whatever you wanted. There were protocols about what could be taken, how much, and by whom. Violating these protocols was a serious social gaffe. Now let's talk about something that may seem bizarre to us: the theatrical presentation of food. Elite medieval banquets weren't just about eating delicious food, they were elaborate visual spectacles. Dishes were presented in increasingly extravagant ways, especially from the 14th century onward. There were what they called subtleties or sotleties, elaborate sculptures made of sugar, pastry, or even molded meat, representing castles, fantastic animals, religious or mythological scenes. These creations were carried in procession to the table, admired by all, and only then, sometimes, eaten. Swans and peacocks were roasted, and then their feathers were carefully replaced so they looked alive when served. Whole pigs were roasted and presented with apples in their mouths. Giant pies were opened to reveal live birds that flew out. Yes, this really happened. Why all this theatre? Because food was entertainment. It was art. It was a way of demonstrating not just wealth, but sophistication, creativity, access to skilled artisans. And here's the interesting part for our discussion of waste. Many of these elaborate presentations were more about appearance than taste. Food was molded, artificially colored, transformed into something visually impressive that might or might not be particularly tasty. Some of these elaborate creations weren't even eaten. They were just for display. After the banquet, they were dismantled and the edible components were redistributed to servants or the poor. But the primary purpose wasn't to feed, it was to impress. This seems incredibly wasteful to us today, using food as decoration, as ephemeral art. But in medieval logic, it made perfect sense. Food was the most valuable resource, so using it to create art demonstrated extreme wealth. It was like building a castle of gold. The point wasn't functionality, it was demonstrating that you could. But let's go beyond elite banquets and talk about community celebrations, because these reveal another dimension of food as social symbol. In medieval communities, there were times in the year when the entire community gathered to celebrate. Successful harvests, religious festivals, weddings, baptisms, all were occasions for community feasts. These feasts functioned differently from noble banquets. They weren't about hierarchy and individual displays of power. They were about community, about reinforcing social bonds, about collective celebration. But food still played a central role. Families contributed what they could. One family brought breads, another brought cheese, another brought homemade beer, another brought a pig or sheep to roast. Everything was shared communally. And here's something beautiful. At these community feasts, waste was minimal, because everything was consumed collectively or immediately redistributed. There were no leftovers because the entire community was there to eat. These feasts also served as a mechanism for wealth redistribution within the community. Wealthier families contributed more, poorer families contributed less, but everyone ate together. It was a way of ensuring that even the poorest had access to quality food occasionally. Compare this with our modern society, where celebrations are often private events, where we eat in restaurants or in our homes, rarely in large community gatherings. We've lost that communal aspect of food, that function of creating and reinforcing social bonds through shared eating. Now let's talk about a darker aspect, food as control. Feudal lords had control over food production on their lands. Peasants worked the land, but a significant portion of what they produced went to the lord as rent, tax, or feudal obligation. This meant that the lord literally controlled who ate and how much. In times of abundance, this control was less visible. But in times of scarcity, it became a brutal tool of power. A lord could choose to feed his loyal servants generously and let troublemakers starve. He could use the promise of food to guarantee loyalty, obedience, work. Food was currency, it was reward, it was punishment. The monasteries, which we discussed earlier as centers of charity, also exercised this kind of control. They decided who received charity and how much. Deserving poor, those considered genuinely needy and of good moral character, received more. Undeserving poor, vagabonds, criminals, those considered lazy, received less or nothing. Moral judgment was embedded in food distribution. And this reminds us that medieval charity, however genuine it might have been in some cases, was also a form of social control. It reinforced hierarchies, rewarded conformity, punished deviation. This is uncomfortable to acknowledge, but it's important. The medieval waste economy wasn't just about efficiency or kindness, it was also about power. Who had it, how they exercised it, how food was used as a tool of that power. And here's an uncomfortable question. Is our modern society really so different? Who controls food production today? Large agricultural corporations. Who decides what's cultivated, how it's distributed, who has access? Complex economic systems that most of us don't understand or control. People starve today not because there isn't enough food in the world, there is abundance. They starve because they don't have the economic power to access that food. It's a different form of control, more abstract but no less real. The medievals were more direct about it. The Lord had the granary, you didn't. Simple. Brutal. But at least honest about the dynamics of power. We hide these dynamics behind markets, prices, consumer choices. But in the end, it's still about who has power over food resources and who doesn't. But returning to medieval banquets, there's another fascinating aspect: the role of intentional waste as a demonstration of virtue. It seems contradictory, right? How can wasting be virtuous? But in medieval logic, especially among the nobility, there was a virtue called magnificence, extravagant generosity, the public display of wealth used for the common good. A nobleman who gave elaborate banquets, who fed hundreds of people, who distributed leftovers generously, was demonstrating magnificence. It wasn't seen as waste, it was seen as appropriate use of wealth. The idea was that God had given wealth to certain people not to accumulate selfishly, but to use for the benefit of others. And extravagant banquets, with all their apparent extravagance, were a way of doing this. Of course, there was hypocrisy in this. Many nobles used this logic to justify personal excess while doing the minimum for the poor. But the idea itself is interesting. The notion that wealth brings obligation, that excess must be shared. Compare this with our modern culture of wealth, where accumulation is often seen as virtue in itself, where billionaires are admired simply for being billionaires, regardless of what they do with that wealth. The medievals, with all their brutal inequality, at least had an ideology that said the rich owed the poor. They didn't always practice this, but the idea was there, embedded in their social and religious structure. We have what? Optional charity, philanthropy as a public relations strategy. There's no real obligation, no strong social expectation that wealth should be shared, and perhaps that's why we have so much waste. Because there's no shame in it. There's no social pressure against it. Throwing away perfectly good food isn't seen as a moral or social failure. It's just normal. For a medieval, especially one of elevated status, to be seen wasting food that could feed others would be a dishonor. It would be seen as a failure to fulfill social and religious obligations. For us, it's just Tuesday. We clean out the refrigerator, throw away food that passed the deadline, and don't think twice. Did we lose something essential in this transition? Or did we gain freedom from oppressive obligations? Probably both. But it's worth reflecting on what was lost along with what was gained. There are still more layers to this story of food as symbol and power. Because we haven't yet talked about sumptuary laws, medieval regulations that literally dictated who could eat what based on their social status. And these laws reveal even more about how food, power, and waste intertwined in medieval society. The lawyers who defended animals in medieval courts were fascinating figures. They weren't comedians or performers, they were serious jurists, many of them highly respected, who applied all their legal knowledge and rhetorical skill to defend clients who couldn't speak, who didn't understand the process, and who certainly couldn't pay their fees. The defenders of the impossible Bartholomew Chasseneuil, that lawyer who defended the rats in Autumn in 1522, wasn't just any attorney. He was one of the most respected jurists of his time. After his brilliant defense of the rats, his reputation grew so much that he eventually became president of the Parliament of Burgundy, essentially one of the most important judges in the region. Think about that. A man achieved one of the most prestigious legal positions of his time, in part because of how well he defended rats. This tells us something important. Defending animals wasn't seen as ridiculous or degrading. It was seen as a test of genuine legal skill, and Chasseneuil really demonstrated extraordinary skill. When the rats didn't appear in court after being summoned, he didn't simply accept defeat. He built a defense based on legal procedure that was both creative and technically sound. His argument was simple but brilliant. If you're going to treat the rats as defendants with legal rights, then you have to actually respect those rights. And one of the fundamental rights is to be adequately notified of the trial. How can you prove that all the rats in the region were notified? You can't. Therefore, the summons is invalid. And without a valid summons, the trial cannot proceed. Furthermore, he argued, the rats have a right to safe passage to the court, but the path is full of cats, their natural predators. Requiring the rats to travel through cat-infested territory to reach the court is to deny them their right to a fair trial. These arguments are ingenious because they use the system's own logic against itself. If you accept the premise that animals can be tried, then you have to accept all the logical implications of that premise, including that they have procedural rights that must be respected. The court was so impressed and so confused about how to respond that the case was repeatedly postponed. And eventually, the rat plague ended naturally, making the case irrelevant. Chassanet had essentially won through strategic delay. But he wasn't the only brilliant lawyer to defend animals. There are records of many others who built sophisticated and sometimes successful defenses. In 1510, a lawyer named Pierre Rimbaud defended a group of caterpillars that was being sued for destroying vineyards. His defense was based on natural theology and Aristotelian philosophy. He argued that God had created all creatures with specific purposes. Caterpillars were created to eat plants. That's their nature, their divine purpose. Punishing them for doing what God created them to do would be questioning God's wisdom. Furthermore, he argued, caterpillars don't have free will. They can't choose not to eat. They simply follow the instincts God gave them. And since moral responsibility requires free will, caterpillars cannot be morally responsible for their actions. These were sophisticated philosophical arguments based on texts by Aristotle and Thomas Aquinas. They weren't improvised or superficial. They were the product of serious education and careful thought. The prosecutor responded with his own theological arguments. He cited Genesis, where God gives humans dominion over animals. This dominion, he argued, includes the right to protect human crops from pests. He also argued that while individual caterpillars don't have free will, the plague as a whole was a manifestation of spiritual forces, possibly demonic, that could and should be fought through legal and religious means. The debate continued for weeks. Expert witnesses were called, theologians, natural philosophers, even other lawyers, to opine on the questions raised. Eventually, the court decided in favor of the humans, but with a compromise solution. The caterpillars were excommunicated and ordered to leave, but the community was also ordered to do penance and improve their moral behavior, recognizing that the plague could be partially caused by their own sins. It was a decision that tried to balance the arguments of both sides, recognizing the partial validity of each position. Are our courts today so different? How many times do we see judicial decisions that try to find middle ground between opposing positions, that recognize the complexity of difficult questions? There were also lawyers who specialized in defending animals. Not officially, of course. There was no animal law specialization at the time. But some lawyers became known for their skill and willingness to take on these difficult cases. And these cases were difficult not just because the client was an animal, they were difficult because they often involved strong emotions, intense community pressure, and limited or contradictory legal precedents. When a child was killed by a pig, the entire community wanted revenge. The lawyer defending the pig faced not just legal arguments, but also anger, pain, and the collective desire to see something, anything, be punished for what had happened. Defending the animal in these circumstances required courage. It required the ability to separate emotion from law, to argue for principles even when those principles were unpopular. In 1499, a lawyer named Jean Duret defended a dog that had bitten several children. The community wanted the dog executed. The parents of the injured children were furious and demanding justice. Duret argued that the dog had been repeatedly provoked by the children, that it was merely defending itself, and that executing it would be unjust. He presented witnesses who described how the children threw stones at the dog and poked it with sticks. He also argued that the dog's owner, a poor man, depended on the animal to protect his small property. Executing the dog would be a severe economic hardship for a family that was already struggling to survive. These arguments were not well received. Duret was accused of blaming the victims, of valuing an animal more than human children. But he persisted, arguing that justice required considering all circumstances, not just reacting emotionally. The court eventually decided that the dog wouldn't be executed, but would be banished from the region, and the owner would pay compensation to the families of the injured children. It was a partial victory for Duret, but also a compromise that recognized the concerns of both sides, and Duret faced social consequences for his defense. There are records that he was publicly criticized, that some in the community avoided him, that his reputation suffered. But he had done his job as a lawyer, defend his client to the best of his ability, regardless of external pressure. This reminds us that being a lawyer in any era sometimes means defending the unpopular, the despised, the one everyone wants to see punished. It's a difficult but essential role in any justice system. There were also cases where multiple lawyers worked together in defending animals. In complex cases involving many animals or particularly complicated legal questions, a defense team could be assembled. In 1520, in a case involving a large locust infestation, 3 different lawyers were appointed to represent the insects. Each specialized in a different aspect of the defense. One focused on procedural issues, another on theological arguments, the third on legal precedents. They worked together to build a layered defense that addressed the case from multiple angles, and they were partially successful. Although the locusts were eventually excommunicated, the court also ordered the community to take measures to improve their agricultural and religious practices. The coordination between these lawyers shows that there was genuine strategy, careful planning, teamwork. It wasn't just one lawyer making random arguments. It was a coordinated and sophisticated legal defense. And the lawyers didn't work for free. They were paid for their work, usually by the court or the community. Records showed detailed payments, both for defense attorneys and prosecutors. Interestingly, lawyers defending animals often received payment similar to lawyers in human cases. This suggests that the work was valued equally, that it wasn't seen as less important or less legitimate. In some cases, there were even disputes about payment. Lawyers argued that animal cases were particularly difficult and deserved additional compensation. Courts sometimes agreed, sometimes didn't. These disputes about payment are curiously mundane. In the middle of all this strangeness of trying animals, there were lawyers worried about their bills, negotiating their fees, complaining when they felt they weren't being paid adequately. It's almost comforting in its normalcy. There were also lawyers who wrote legal treatises about animal trials. These texts analyzed precedents, discussed legal principles, and offered guidance on how these cases should be conducted. One of the most famous was written by Bartholomew Chassenet, yes, the defender of the rats. His treatise, Concilia, included extensive sections on proper procedures for trying animals, arguments that could be used in defense, and how to balance legal, theological, and practical considerations. This treatise was widely read and cited by other lawyers and judges. It became a standard reference for animal cases, and this shows that there was a developing jurisprudence, a body of knowledge and precedent that was being systematized and transmitted. Other jurists also wrote about the subject. There were academic debates about questions like, do animals have souls? Can they sin? Do they have free will? How does moral responsibility apply to non-rational beings? These weren't trivial questions at the time. They were serious philosophical and theological questions that had practical implications for how legal cases were decided, and the lawyers who participated in these debates weren't marginal or eccentric. They were often law professors at prestigious universities, advisors to kings and bishops, respected figures in the intellectual world of the time. This tells us something important. Trying animals wasn't a marginal or ridiculous practice. It was part of the legal and intellectual mainstream of medieval and early modern Europe. There were also cases where lawyers used animal trials as a platform for broader political or social arguments. The defense of an animal could become a veiled critique of authorities, a discussion about rights and justice that had implications beyond the specific case. In 1518, a lawyer defending a group of rats used the case to argue about the rights of the poor. He compared the rats, who were just trying to survive by eating what they found, to poor peasants who sometimes had to steal food to avoid starving. He asked, "If we punish rats for following their survival instincts, but often execute poor humans for stealing food, what does this say about our justice? Are we being more merciful to animals than to our own fellow humans?" These arguments didn't save the rats. They were excommunicated anyway, but they started discussions in the community about poverty, justice, and how the law was applied differently to rich and poor. Using an animal case as a platform for social critique was risky. It could offend authorities, could be seen as disrespectful to the court. But some lawyers were willing to take that risk using the only tools they had to raise important questions. And there were cases where the defense of an animal became about fundamental legal principles, about the right to a fair trial, about presumption of innocence, about the need for adequate evidence. In 1505, a lawyer defending a horse accused of killing its handler argued that the evidence was circumstantial. Yes, the handler was found dead near the horse, but no one actually saw the horse kill him. It could have been an accident, it could have been another cause. He argued that convicting based on circumstantial evidence, without direct witnesses, would set a dangerous precedent. If a horse could be convicted without definitive proof, what would prevent humans from being convicted the same way? The court took this argument seriously. They debated extensively about what level of proof was necessary. Eventually, they decided that the evidence was sufficient in this case, but established clearer guidelines about standards of proof for future cases. So, the defense of a horse ended up contributing to the development of legal principles about evidence and proof that applied to all cases, not just animals. This shows that these animal trials, however strange they seem, were part of the ongoing development of the legal system. They were laboratories where principles were tested, where boundaries were explored, where the logic of law was taken to its extreme conclusions. And the lawyers who participated in these cases were, consciously or not, contributing to the evolution of legal thought. They were asking difficult questions, challenging assumptions, forcing courts to think carefully about what justice really means. Of course, they were doing all this within a framework that seems absurd to us, the idea that animals can be criminally responsible. But the principles they developed about proper procedure, about rights of defense, about standards of evidence, these principles transcended that strange framework and contributed to legal systems we recognize today. And maybe that's the most important lesson about these lawyers defending animals. That they show us that legal progress often happens in unexpected places through cases that seem trivial or absurd. That important principles can be developed even in strange contexts, and that the work of lawyers, defending the indefensible, arguing for the unpopular, insisting on proper procedure, even when everyone wants shortcuts, that work is essential, no matter how strange the case may seem. But there's still another dimension of these trials we need to explore, how they eventually came to an end, because this practice, which lasted for centuries, eventually disappeared. And the reasons for its disappearance tell us a lot about how human thinking evolves, how societies change, and how practices that once seemed perfectly rational can become unthinkable. The practice of trying animals didn't disappear suddenly. It was a gradual decline that extended over centuries, driven by profound changes in how people understood the world, nature, law, and humanity's place in the universe. And the story of this decline is as fascinating as the story of the trials themselves. The beginning of the end, the last well-documented animal trial in Europe, occurred in 1741 in France. a case involving a cow that had supposedly caused a person's death. The case followed all the traditional procedures: formal summons, appointed defense attorney, witnesses heard, sentence pronounced. But something had changed. Records show there was significant debate about whether the trial should even happen. Some officials argued that trying a cow was an outdated, superstitious practice, unworthy of an enlightened age. Others defended the tradition, citing centuries of precedents, arguing that abandoning the practice would be denying the wisdom of previous generations. Eventually, tradition won. The trial proceeded. But the fact that there was debate, that the practice was openly questioned, shows that something fundamental was changing in the European mentality. So what changed? Why did a practice that had been accepted for centuries suddenly begin to seem strange, even absurd? The answer lies in several interconnected changes that were transforming European society between the 16th and 18th centuries. First, there were changes in scientific understanding of nature. The development of modern science, beginning with figures like Galileo, Newton, and others, was creating a new way of understanding the natural world. Animals began to be seen not as participants in a moral and spiritual order, but as biological machines operating according to natural laws. Descartes famously argued that animals were automata, complex machines without real consciousness, without souls, without capacity for thought or moral choice. If animals are just machines, then trying an animal makes as much sense as trying a rock that falls and hurts someone. The rock didn't choose to fall, it simply obeyed gravity. Similarly, an animal that attacks isn't making a moral choice, it's just following its biological programming. This mechanistic view of animal nature made the idea of animal criminal responsibility increasingly difficult to justify. Second, there were changes in understanding of law. The development of modern legal thought, influenced by the Enlightenment, was creating a clearer separation between law and religion, between the legal and the spiritual. Law began to be seen as something created by humans to serve human purposes, not as a reflection of cosmic divine order. And if law is a human tool to regulate human behavior, then applying it to animals doesn't make sense. Enlightenment thinkers like Voltaire and Montesquieu openly ridiculed the practice of trying animals. They saw it as an example of medieval superstition, of confused thinking that mixed categories that should be kept separate. Voltaire wrote sarcastically about animal trials, using them as examples of how irrational and absurd medieval Europe had been. For him and other Enlightenment thinkers, abandoning these practices was a sign of progress, of reason triumphing over superstition. If you're enjoying this journey, subscribe to the channel so you don't miss our next stories. Third, there were changes in social and economic structure. Europe was urbanizing. More people lived in cities where animals were less present in daily life. The relationship between humans and animals was changing. In medieval rural life, animals and humans lived in much closer proximity. Pigs roamed the streets. Horses and oxen were an essential part of the economy. Animal attacks were real and frequent risks that everyone faced. But in modern urban life, animals were more controlled, more distant, and as they became more distant, the need for elaborate rituals to deal with problematic animals diminished. Additionally, new forms of insurance and compensation were developing. If your animal caused damage, there were more direct economic mechanisms to deal with it. You didn't need an elaborate trial, you just paid compensation, or your insurance covered the damages. Fourth, there were changes in religious attitudes. The Protestant Reformation had questioned many traditional Catholic practices, and although animal trials weren't exclusively Catholic, they were deeply intertwined with Catholic rituals and beliefs. In Protestant areas, especially those influenced by Calvinism, there was growing skepticism about elaborate rituals, about the idea that words and ceremonies could control the natural world. There was greater emphasis on God's sovereignty and the futility of human attempts to manipulate creation through rituals. This doesn't mean Protestants never tried animals. There are records of cases in Protestant areas. But the practice was less common and faced more questioning. And fifth, there was simply generational change. Each new generation grew up in a slightly different world, with slightly different ideas, and practices that their grandparents considered normal began to seem strange. There's a recognizable pattern here. Social practices don't disappear because someone proves they're wrong. They disappear because the world changes in ways that make them irrelevant or incomprehensible. Trying animals made perfect sense in a world where animals and humans lived in intimate proximity, where law was seen as a reflection of divine order, where rituals were understood as having real power over the natural world. But as each of these elements changed, as animals became more distant, as law became more secular, as science offered new explanations for natural phenomena, trying animals made less and less sense. It wasn't a sudden change, it was a gradual process of erosion. First, cases became less frequent. Then, when they occurred, they faced more questioning. Eventually, they stopped completely. And it's fascinating to note that different regions abandoned the practice at different times. More urban areas, more connected to modern intellectual currents, stopped earlier. Rural areas, more conservative, maintained the practice longer. This reminds us that cultural change isn't uniform. It spreads unevenly, affecting different communities at different times. But there's something more interesting about the end of animal trials. They weren't formally abolished. There was no law saying, from now on, trying animals is prohibited. They simply stopped happening. People stopped bringing animals to trial because the practice began to seem strange, outdated, embarrassing. No one wanted to be seen as superstitious or backward. So, quietly, without fanfare, the practice disappeared. And then something curious happened. People began to forget that this had ever been normal. Within a few generations, animal trials were seen as historical oddities, examples of how irrational the past had been. 19th century writers rediscovered records of these trials and were fascinated and horrified. How could intelligent people have done something so obviously absurd? How could entire societies have participated in this madness? But this reaction reveals a blind spot. It assumes that we, moderns, are rational in ways our ancestors weren't, that we see the world clearly while they were lost in superstition. The truth is more complex. The people who tried animals weren't less intelligent or less rational than us. They simply operated within a different framework of understanding, a framework that made sense given what they knew and believed, and we, moderns, also operate within frameworks of understanding. We also have blind spots. We also do things that future generations will find bizarre or absurd. Will people 500 years from now look at our current practices with the same amazement we feel looking at medieval animal trials? Probably. Maybe they'll be shocked by how we treated animals on industrial farms, or how we dealt with artificial intelligence, or our legal structures around corporations, or any number of other practices we consider perfectly normal. The point isn't to judge the past or feel superior. The point is to understand that all societies, including ours, operate within frameworks of understanding that are partially constructed, partially arbitrary, and that will inevitably change over time. But returning to the decline of animal trials, there's a particularly interesting aspect. Some elements of the practice didn't completely disappear. They transformed. The idea that animals that cause harm should be punished didn't disappear. We still kill dogs that bite people. We still slaughter animals that become dangerous. We just don't formally try them first. The idea that animal owners have legal responsibility for damage caused by their animals also didn't disappear. Modern laws about animal liability are direct descendants of principles developed in these medieval trials. And the idea that law should follow proper procedures, that defendants have rights that must be respected, that adequate evidence is necessary for conviction, all these principles that were developed and refined in animal trials continue to be fundamental to modern legal systems. So in a way, animal trials didn't really disappear. They transformed, evolved, were incorporated into modern practices in ways we don't immediately recognize. It's like biological evolution. Old characteristics don't simply disappear, they transform, are adapted for new contexts, continue existing in modified forms, and there are even surprisingly direct modern echoes. In some places, there are current debates about whether great apes, or dolphins or elephants, should have some form of legal personhood, whether they should have legal rights that can be defended in court. These debates use modern language and are based on modern scientific understanding of animal cognition. But they are, in a way, revisiting questions that those medieval lawyers defending rats and locusts were already exploring. What rights do non-human beings have? How should the legal system recognize and protect those rights? We're not trying animals for crimes anymore, but we're still struggling with questions about the legal status of animals, about responsibility, about how to balance human and non-human interests. And some countries have already recognized rivers as having legal rights, not because rivers can commit crimes, but because giving them legal status is a way to protect them. It's an idea that those medieval jurists, with their willingness to extend legal concepts to non-human beings, might understand. So maybe animal trials aren't as distant from us as we think. Maybe they're just an earlier, stranger version of ongoing struggles about how the legal system should deal with the non-human world. And maybe, instead of laughing or being horrified by these trials, we should see them as part of a long, ongoing conversation about justice, responsibility, and our place in the natural world. A conversation that began long before us and will continue long after. But there's still one final aspect of these trials we need to explore: what they really teach us. Because after diving deep into this strange and fascinating history, the question remains: why does this matter? What can we learn from people who tried pigs and excommunicated locusts? After exploring this strange and fascinating history in depth, we arrive at the most important question. What do medieval animal trials really teach us? Why should we care about people who tried pigs and excommunicated locusts centuries ago? Lessons from a strange past. The first and perhaps most important lesson is about historical empathy. It's easy to look at the past and laugh or be horrified or feel superior. How could they be so foolish, we think? How didn't they see the absurdity of what they were doing? But this reaction misses the point. The people who tried animals weren't foolish. They were intelligent, careful, serious. Many were highly educated: lawyers, judges, theologians, philosophers. They simply lived in a different world with different frameworks of understanding. And here's the crucial lesson: we also live within frameworks of understanding. We also have beliefs and practices that will seem strange or absurd to future generations. We also have blind spots. Recognizing this isn't relativism. It's not saying all beliefs are equally valid. It's simply recognizing epistemic humility. It's admitting that our understanding of the world is partial, constructed, subject to change, and this humility is important. It makes us more careful in our judgments, more open to questioning our own assumptions, more aware that what seems obvious to us may not be obviously true in any absolute sense. The second lesson is about the nature of justice. Animal trials reveal something fundamental about what justice systems really do. Superficially, justice systems exist to punish the guilty and protect the innocent, but they also serve deeper psychological and social functions. They help communities process trauma. When something terrible happens, a child killed, crops destroyed, people need a way to make sense of chaos. to feel that something is being done, to restore a sense of order. Animal trials offered that. They were elaborate rituals that transformed random tragedy into comprehensible narrative. It wasn't just bad luck, it was a crime. And the criminal was tried and punished. Justice was done, order was restored. We still do this today, just in different ways. When there's a tragedy, we look for someone to blame, someone to sue, someone to punish. Not just because it prevents future tragedies, though sometimes it does, but because psychologically we need to feel the world is just, that actions have consequences, that we're not completely at the mercy of chance. So, animal trials teach us that justice isn't just about logic or efficiency. It's also about ritual, about narrative, about deep human needs for meaning and order. The third lesson is about the relationship between law and society. Animal trials didn't exist in a vacuum. They reflected and reinforced broader social structures. They reflected religious beliefs about divine order and the place of humans and animals within it. They reflected economic structures where animals were valuable property and damages needed compensation. They reflected social hierarchies where rich and poor, nobles and peasants, had different levels of power and access to justice. And they reinforced all these structures. Each trial was a public reaffirmation of how the world worked, of who had power, of which values were important. This reminds us that law is never neutral. It always exists within social contexts, always reflects and reinforces certain structures of power and belief. And recognizing this is important for understanding how our own legal systems work. The fourth lesson is about cultural change. Animal trials show us how social practices arise, persist, and eventually disappear. They arose from a combination of religious beliefs, practical needs, and existing legal structures. They persisted because they served important functions: psychological, social, economic. And they disappeared when the world changed in ways that made them irrelevant or incomprehensible. There was no decisive moment where someone proved that trying animals was wrong and everyone stopped. It was a gradual process of erosion as multiple changes, scientific, philosophical, economic, social, accumulated until the practice simply no longer made sense. And this is how most cultural change happens. Not through decisive rational arguments, but through gradual changes at multiple levels that eventually make old practices obsolete. Understanding this can make us more patient with changes we want to see and more aware that real change requires transformation at multiple levels, not just better arguments. The fifth lesson is about human creativity in the face of the impossible. The lawyers defending animals, the courts trying to apply legal procedures to defendants who couldn't speak or understand, the communities trying to deal with threats they couldn't control, all demonstrated extraordinary creativity. They took tools they had, law, religion, ritual, and applied them to situations for which these tools weren't originally designed. And in the process, they developed sophisticated arguments, elaborate procedures, creative solutions. Yes, the basic premise that animals can be criminally responsible was flawed, but the work done within that premise was often brilliant, and some of the principles developed about proper procedure, about rights of defense, about standards of evidence, transcended the flawed premise and contributed to legal systems we recognize today. This teaches us that progress can come from unexpected places, that even work based on mistaken premises can produce valuable insights, that we should evaluate ideas on their merits, not just their origins. The sixth lesson is about responsibility. Animal trials were, in part, about determining who or what was responsible when something bad happened, and they reveal tensions we still face. When an animal causes harm, who's responsible? The animal, the owner, the community that allowed certain conditions, forces beyond human control? Today we ask these same questions in different contexts. When an autonomous car causes an accident, who's responsible? The car, The programmer? The manufacturer? The owner? When an AI makes a harmful decision, who answers? These are modern versions of ancient questions about responsibility, agency, and how to assign blame in complex systems. And medieval animal trials, with all their attempts to navigate these questions, can offer useful perspectives. The seventh lesson is about the power of ritual. Animal trials were elaborate rituals, carefully choreographed public performances that served multiple purposes. They educated the community about law. They reaffirmed social values. They offered emotional catharsis. They created social cohesion through shared participation. They transformed chaos into order through structure and procedure. And they remind us that rituals matter. Not just religious rituals, but legal rituals, social rituals, rituals of any kind that help communities process experiences, affirm values, create meaning. Our own societies have legal rituals, trials, sentencings, executions where they still exist, police academy graduation ceremonies, judges' oaths. And these rituals serve similar functions, not just practical, but also symbolic, psychological, social. Recognizing the power and importance of ritual can help us better understand how our own institutions work and why certain procedures that seem unnecessary or inefficient may actually serve important purposes. The eighth lesson is about the line between humans and animals. Animal trials existed in a time when that line was more blurred than it is today. Animals were seen as having some level of moral agency, some capacity for choice, some responsibility for their actions, not to the same degree as humans, but also not as completely absent. Today, modern science tells us that many animals have more complex cognition than we thought. They have emotions, memories, problem-solving ability, even rudiments of culture and morality. So maybe those medieval people who saw animals as having some level of agency weren't completely wrong. Maybe they were recognizing something real, even if they expressed it in ways that seem strange to us. And this raises important questions about how we should treat animals, what rights they should have, how our legal systems should recognize their capacity and value. And you, what do you think about this? Leave your opinion in the comments. The ninth lesson is about the nature of rationality. It's tempting to see animal trials as examples of irrationality, of confused thinking, of failure to apply logic properly. But that would be a mistake. The people involved in these trials were rational. They applied logic carefully. They built sophisticated arguments. They followed elaborate procedures. The problem wasn't lack of rationality. It was that they were being rational within a framework of premises we no longer share. If you accept that animals are part of a divine moral order, that they have some level of agency, that legal and religious rituals have real power over the natural world, then trying animals is perfectly logical. The problem isn't the logic, it's the premises. And this is a crucial lesson because it reminds us that rationality isn't enough. You can be perfectly rational and still reach wrong conclusions if your premises are wrong. This should make us more humble about our own rationality, more careful in examining our premises, more open to questioning assumptions that seem obvious. The 10th lesson is about historical continuity. It's tempting to see the past as completely different from the present, as a foreign country where everything is strange. But animal trials reveal deep continuities. The human needs they served, one for justice, for order, for meaning, for control, are the same needs we have today. The tensions they navigated between justice and mercy, between punishment and practicality, between different competing interests, are tensions we still face. We've changed the tools, we've changed the frameworks of understanding, but the fundamental challenges of living in society, of creating justice systems, of dealing with the unexpected and uncontrollable, these remain remarkably constant. And recognizing this continuity can give us perspective. It can help us see our own challenges as part of broader, enduring human struggles. It can connect us with past generations in ways that go beyond superficial differences. The 11th lesson is about the importance of context. We can't understand animal trials in isolation. We have to understand them within their contexts: religious, legal, social, economic, intellectual. And this is true for any practice or belief. Nothing exists in a vacuum. Everything is intertwined with broader structures of meaning and practice. This makes us better at understanding not just the past, but also the present. When we see practices that seem strange to us in other cultures, in other times, we can ask, what context makes this comprehensible? What needs does this serve? What broader structures does this reflect? And when we examine our own practices, we can ask the same questions. What contexts make our practices comprehensible? What needs do they serve? And how might they seem to someone outside these contexts? The 12th lesson is about the nature of history. Animal trials remind us that history isn't a linear march of progress from irrational to rational, from superstitious to scientific, from primitive to advanced. It's more complicated than that. It's a series of changes, some progressive, some not, some ambiguous. It's intelligent people doing the best they can with the tools and understandings they have. It's practices that serve important purposes in their own contexts, even if they seem strange outside them. And understanding history this way, not as a simple story of progress, but as a complex tapestry of change and continuity, makes us wiser, more humble, more capable of learning from the past without judging it unfairly. So what do medieval animal trials teach us? They teach us about empathy, about justice, about change, about creativity, about responsibility, about ritual, about the line between humans and animals, about rationality, about continuity, about context, about history. They teach us that the past is strange but also familiar, that people were different from us but also surprisingly similar, that we can learn from practices that seem absurd if we're willing to look deeper. And perhaps above all, they teach us humility. Humility about our own understanding, about our own practices, about our own time. Because if intelligent and careful people could try pigs and excommunicate locusts and find it perfectly reasonable, then surely we also have blind spots, also do things that will seem strange to future generations. And recognizing this doesn't make us less confident. It makes us wiser. It makes us more open to questioning, to learning, to changing. And these are qualities that every society in every age desperately needs. But there's still one last reflection we need to make. What all this means for us, today, now, how these lessons apply to our modern world with our own challenges and questions. And it's this final connection between past and present that can make this strange story truly relevant and powerful. So how do these lessons from medieval animal trials connect with our modern world? How can this strange story of hanged pigs and excommunicated locusts help us understand our own challenges and dilemmas? The answer is, in surprisingly direct and relevant ways, echoes. In the modern world, let's start with something happening right now, debates about artificial intelligence and algorithmic responsibility. When an AI algorithm makes a decision that harms someone, unfairly denies a loan, recommends wrong medical treatment, causes an accident in an autonomous car, who's responsible? Is it the algorithm? Is it the programmer who created it? Is it the company that deployed it? Is it the user who activated it? Or is it some complex combination of all these factors? These questions are strangely similar to those medieval courts faced. When an animal caused harm, was the animal responsible? Was the owner? Was the community? Was God working through the animal? And the solutions we're developing today, distributed responsibility frameworks, algorithmic transparency requirements, AI regulations, echoes some of the medieval solutions, holding multiple parties accountable, requiring owners of systems to take precautions, creating legal structures that recognize the complexity of assigning blame in systems where agency is distributed. We're not trying algorithms in courts, but we're struggling with very similar questions about how legal systems should deal with entities that have some kind of agency but aren't human. Another modern parallel: debates about animal rights and legal personhood. In several countries, there are movements to recognize certain animals, great apes, elephants, dolphins, as having legal rights that can be defended in court. In 2015, an Argentine court granted an orangutan named Sandra certain legal rights, declaring her a non-human person with a right to freedom. In 2018, India's Supreme Court declared that animals have rights as living entities. Several countries have recognized that animals are sentient beings with special legal protections. These developments are, in a way, a return to ideas those medieval jurists were exploring. The idea that non-human beings can have legal status, can have rights that the legal system must recognize and protect. Of course, we're doing this for different reasons and in different ways. We're not trying animals for crimes. We're recognizing their capacity to suffer, their cognitive complexity, their intrinsic value, but there's a conceptual continuity. Both involve extending legal concepts beyond the purely human domain. Both recognize that the line between humans and non-humans is more complicated than it first appears, and there are even modern cases that directly echo medieval trials. In 2016 in India, there was a case where an elephant that had killed a person was brought to a kind of trial. Not a formal criminal trial, but a legal process to determine its fate. There were arguments about whether the elephant was acting defensively, whether it had been provoked, whether it should be executed or relocated. There were lawyers arguing different positions. There were considerations of precedents and legal principles. Sound familiar? It's almost exactly the kind of process that happened in medieval courts, just with modern language and justifications. Another modern echo: how we deal with natural disasters and the need to assign responsibility. When a hurricane destroys a city, when a pandemic kills thousands, when a drought ruins crops, we modern rational humans know these are natural phenomena, not acts of malicious agency. But still, we look for someone to blame. We blame politicians for inadequate preparation. We blame companies for contributing to climate change. We blame other countries for not containing the pandemic quickly enough. And there's something deeply human in this, something that connects directly with those medieval communities suing locusts. When we face the uncontrollable, when we suffer losses that seem random and meaningless, we need to transform it into narrative. We need to find agency and responsibility, even when reality is more complex. We're not excommunicating hurricanes, but we're doing something psychologically similar, transforming natural forces into narratives of human responsibility that we can process and deal with. There are also parallels in how we deal with technology that fails. When a plane crashes, when a bridge collapses, when a nuclear reactor fails, there are elaborate investigations, public hearings, legal proceedings, and these processes serve similar functions to medieval animal trials. They educate the public. They reaffirm that there are standards and consequences. They offer victims and their families a sense that justice is being done. They transform chaotic tragedy into ordered narrative. Of course, they also serve practical purposes, identifying causes, preventing future accidents. But the ritual dimension, the psychological and social function, is also there, and recognizing this can help us understand why these processes sometimes seem excessively elaborate or emotionally charged, because they're not just about technical facts, they're also about deeper human needs. Stay with me until the end, because what comes next will surprise you. Another fascinating parallel: Debates about corporations and legal personhood. Legally, corporations are persons in many legal systems. They can own property, sign contracts, sue, and be sued. But when a corporation does something wrong, pollutes the environment, sells dangerous products, exploits workers, who's really responsible? The corporation as an abstract entity, the executives who made decisions, the shareholders who profited, the employees who implemented policies? These questions about corporate responsibility echo medieval debates about animal responsibility. In both cases, we're trying to apply concepts of responsibility and punishment to entities that aren't simple human individuals. And the solutions we've developed, corporate fines, criminal prosecutions of executives, governance requirements, are attempts to navigate these complexities, just as those medieval courts navigated the complexities of trying animals. There are also parallels in how we deal with online behavior and digital responsibility. When someone is harassed online, when misinformation spreads, when algorithms promote harmful content, who's responsible? Is it the individual who posted? Is it the platform that hosted? Is it the algorithm that amplified? Is it the society that created conditions for this? Again, we're dealing with distributed responsibility in complex systems, and we're developing legal and social structures to deal with it. Content moderation, platform regulations, social norms about online behavior. It's not so different from how those medieval communities developed structures to deal with problematic animals. A combination of individual responsibility, the owner, collective responsibility, the community, and recognition that some factors are beyond human control. And there's a particularly powerful parallel in how we deal with climate change. It's a problem caused by billions of individual actions over decades. Responsibility is distributed so widely that it's difficult to assign blame meaningfully, but still, we try. We sue fossil fuel companies, we create international agreements, we set emissions targets, we hold elaborate conferences where countries negotiate responsibilities. And there's something in these rituals, because they are rituals in part, that echoes those medieval ceremonies of insect excommunication. We're using legal and diplomatic tools to try to impose order and control over forces that are, in many ways, beyond our complete control. This doesn't mean these efforts are useless. They can have real practical effects. But recognizing the ritual dimension, the psychological and social function, can help us understand why these processes are so emotionally charged and why they sometimes seem inadequate to the scale of the problem. There are also lessons about how change happens. Animal trials didn't end because someone proved they were wrong. They ended because the world changed in ways that made them irrelevant. And this is relevant to changes we want to see today. If we want to change how we treat animals, how we deal with AI, how we respond to climate change, it's not enough just to argue that current practices are wrong. We need to change the underlying structures, economic, social, cultural, intellectual, that make current practices comprehensible and sustainable. We need to create a world where different practices make more sense. This is harder than just arguing, but it's how real change happens. And there are lessons about empathy and understanding. It's easy to look at practices that seem strange to us, in other cultures, in other times, and judge them as irrational or morally inferior. But animal trials teach us to ask better questions. What context makes this comprehensible? What needs does this serve? What can we learn from this, even if we don't agree with it? These are useful questions not just for understanding the past, but also for navigating our diverse and complex world today. When we encounter practices that seem strange to us, in other cultures, in other communities, we can apply the same empathetic curiosity. It doesn't mean accepting everything uncritically. It means understanding before judging, seeking context before condemning, recognizing complexity instead of assuming simplicity. There are also lessons about the importance of procedure and ritual. We live in an age that values efficiency, that often sees elaborate procedures as unnecessary obstacles. But animal trials remind us that procedure and ritual serve important purposes. They ensure justice. They create legitimacy. They offer people a sense that they were heard, that the process was fair, that the decision has weight and meaning. This is relevant to current debates about legal reform, about simplifying bureaucracies, about government efficiency. Yes, we should eliminate genuinely unnecessary procedures, but we should be careful not to eliminate rituals that serve important functions, even if those functions aren't immediately obvious, and there are lessons about humility. If intelligent and careful people could try pigs and find it perfectly reasonable, then surely we also have blind spots. What current practices will seem absurd in 500 years? What assumptions we consider obvious will be questioned? What frameworks of understanding we inhabit will be seen as limited or mistaken? We can't know for sure. But we can cultivate humility, openness to questioning our own assumptions, willingness to consider that we might be wrong about things that seem obvious. And perhaps the most important lesson of all, the past isn't just a foreign country, it's also a mirror. When we look at it, we see not just difference, but also similarity, not just strangeness, but also shared humanity. The people who tried animals faced challenges fundamentally similar to ours: how to create justice, how to deal with the uncontrollable, how to assign responsibility, how to live together in community, how to make sense of a frequently chaotic and incomprehensible world. They used different tools, they operated within different frameworks, but the struggles were the same. And recognizing this can connect us with them across the centuries, can help us see our own time more clearly, can make us wiser in how we navigate our own challenges, because in the end, we're not so different from those lawyers defending rats, from those judges pondering the culpability of pigs, from those priests excommunicating locusts. We're all humans, trying to do the best we can with the tools and understandings we have, trying to create order and meaning, trying to be fair, trying to protect our communities. And if we can look at them with empathy and understanding, despite all the differences, maybe we can apply that same empathy and understanding to each other across all the differences that divide us today. That may be the most powerful lesson of all. And it's a lesson our world, with all its divisions and conflicts, desperately needs. But there's still one last dimension of this story we need to explore. Not just what it teaches us, but how it makes us feel. Because history isn't just about lessons and insights, it's also about emotional connection, about wonder, about the experience of finding humanity in unexpected places. And it's this emotional dimension that can make this story truly transformative. There's something deeply moving about imagining those scenes. A medieval lawyer dressed in his formal robes, standing in a courtroom, passionately arguing for the life of a sow. A priest solemnly reading an excommunication to a field full of locusts. An entire community gathered to witness the execution of an animal, seeking some sense of justice, some closure for their pain, the humanity behind the absurd. When you really stop and imagine these scenes, not as abstract historical curiosities, but as real moments lived by real people, something changes. The absurdity doesn't disappear, but it's accompanied by something more: recognition, empathy, even a kind of tenderness, because what you see when you look beyond the surface strangeness are people trying to make sense of a world that often doesn't make sense, trying to create justice in situations where justice seems impossible, trying to protect their communities with the only tools they have. Think about that lawyer defending rats, Bartholomew Chassenet. He wasn't doing it for money, the rats certainly couldn't pay. He was doing it because he believed in something. Maybe it was professionalism. Every defendant deserves adequate defense, even if it's a rat. Maybe it was principle. All beings created by God have rights that must be respected. Maybe it was simply the intellectual challenge of building the best possible defense in impossible circumstances. But whatever the reason, there was real dedication there. There was care, effort, intelligence applied to a problem he took seriously. And there's something admirable in that, even if we disagree with the basic premise. Or think about those parents in Falaise whose child was killed by the sow. Their pain was real, their desire for justice was real, and when they saw the sow tried, condemned, dressed in human clothes and publicly executed, it probably offered some comfort. Not because the pain disappeared, pain like that never completely disappears, but because they felt their loss was acknowledged, that the community cared enough to do something, that they weren't alone in their suffering, and there's something deeply human in that. This need for acknowledgement, for ritual, for transforming private tragedy into a public event that the community witnesses and validates. We still do this through funerals, memorials, trials of people who caused harm. The forms have changed, but the need remains. Or think about those desperate farmers, watching their crops being destroyed by locusts, knowing their families might starve in winter. When the priest came and performed the excommunication ceremony, when he solemnly read the order for the insects to leave, it probably offered some hope, some sense that they weren't completely powerless, that there was something they could do besides passively watch the destruction. Was this hope justified? Scientifically, no. The ceremony had no real effect on the insects. But psychologically, socially, maybe yes. Maybe it gave them strength to continue, not to give up. Maybe it united the community in shared purpose. Maybe it offered structure and meaning in a situation that would otherwise be just random chaos. And who are we to say that had no value? That psychological comfort, hope, community cohesion don't matter just because they're based on beliefs we don't share. There's also something touching in the seriousness with which all this was done. These weren't rushed or superficial rituals. They were elaborate, careful processes that followed established procedures that took significant time and resources. When an animal was tried, it wasn't a farce. It was a real trial with all the formalities. Lawyers prepared arguments, witnesses were heard, evidence was examined, judges deliberated carefully, and there's something admirable in this dedication to proper procedure, even in circumstances that seem absurd to us. They were saying, if we're going to do this, we're going to do it right, we're going to respect the law, we're going to follow the rules, we're going to ensure it's fair. This reveals a commitment to justice that transcends the specific case, a recognition that how we do things matters as much as what we do. That proper procedure isn't just bureaucracy, it's the very essence of justice. And when you think about the defense attorneys, there's something almost heroic in their willingness to defend the indefensible. They knew they were defending animals, that their clients couldn't thank them, that they'd probably face criticism or ridicule, but they did it anyway, because they believed every defendant deserves defense, because they believed in principles that were bigger than any individual case, because they had the courage to defend the unpopular. And that's something we recognize and value even today. Lawyers who defend despised clients, who argue for principles even when it's difficult, who insist on proper procedure even when everyone wants shortcuts. These are essential pillars of any justice system. Those medieval lawyers defending animals were doing exactly that. And there's something inspiring in that, something that connects us with them across the centuries. There are also moments of genuine humor in this story. Not humor of mockery, but humor of recognizing human absurdity, including our own. Imagine being the court official assigned to read a summons to a field full of locusts. You're standing there, formally dressed, holding a legal document, solemnly reading to insects that obviously aren't paying attention. Don't you feel even a little ridiculous? Isn't there a moment where you think this is absurd? Probably yes. But you do it anyway because it's your job, because it's what the system requires, because maybe, on some level, you understand that the ritual has value, even if the literal logic is questionable. And there's something very human in this capacity to do things that part of you knows are a bit absurd. but that you do anyway because they serve a larger purpose. We all do this. We participate in rituals, we follow conventions, we do things that don't make literal sense but make social or psychological sense. So when we laugh at that official reading to locusts, we're also, in a way, laughing at ourselves. And there's something healthy in that, something that keeps us humble. There are also moments of genuine tragedy in this story. Those piglets that were acquitted but lived under constant threat of execution. That valuable horse that killed its handler and had to be branded and sold. That sow dressed in absurd human clothes being led to execution. These are moments that, if you really imagine them, are sad. They're animals that didn't understand what was happening, that had no choice, that were trapped in human systems they couldn't comprehend. And there's something in this tragedy that makes us reflect on how we treat animals today. Yes, we don't try them in courts anymore, but we still kill them on a large scale, still use them for our purposes, still subject them to systems they don't understand. So maybe we're not so different, maybe we've just changed the forms, but the fundamental reality that animals often suffer due to human decisions they can't comprehend or influence remains. And recognizing this isn't necessarily condemning all modern practices. It's simply recognizing complexity, recognizing that we don't have all the answers, recognizing that future generations may look at our practices with the same discomfort we feel looking at medieval animal trials. And you, what do you think about this? Leave your opinion in the comments. But perhaps the most moving moment of all is imagining those communities gathered to witness these trials and executions. Entire families, children being lifted by parents for a better view, neighbors talking in low voices, all united in a shared ritual. They weren't there just for morbid entertainment, though there was certainly an element of that. They were there because these events mattered, because they were about their community, their safety, their values, their understanding of how the world works. And when the trial ended, when the sentence was executed, when everyone went home, they took something with them. Maybe it was a renewed sense that justice exists. Maybe it was comfort that the community cares for its members. Maybe it was simply the shared experience of having witnessed something significant together. And there's something beautiful in that. In this human capacity to create meaning through ritual, to unite through shared experience, to transform individual events into community moments. We still do this, of course, through public trials, through memorials, through civic ceremonies of all kinds. The forms have changed, but the underlying human need for shared ritual, for collective meaning, for community united through common experience remains. And when we recognize this, when we see this continuity, something happens. Those medieval people no longer seem so distant, so strange, so different. They seem human, like us, struggling with the same fundamental challenges, using different tools, but motivated by the same needs. And there's something deeply comforting in that, because it means we're not alone, that the challenges we face of creating justice, of dealing with the uncontrollable, of living together in community, are challenges humans have always faced. That there's accumulated wisdom from generations we can access if we're willing to look beyond superficial differences. It also means we don't need to have all the answers. Those medieval people didn't. They were doing the best they could, trying things, sometimes getting it wrong, sometimes getting it right. And we're doing the same. And maybe 500 years from now, people will look at our practices with the same mixture of amazement, confusion, and, we hope, empathy and understanding. They'll see that we were trying, that we cared, that we used the tools we had to face challenges that often seemed impossible, and maybe they'll learn something from us, just as we learn from those people trying animals. Not necessarily that we were right. We'll probably be wrong about many things, but that we were human, that we tried, that we cared. And in the end, maybe that's what history really is, not just a collection of facts about the past, but an ongoing conversation across time where each generation tries to understand the previous ones, learns from them, and contributes its own part to the conversation that will continue after we're gone. Animal trials are part of that conversation, a strange, fascinating, sometimes disturbing but also deeply human part. And by engaging with this history, by trying to understand it, by reflecting on what it teaches us, by recognizing our own humanity reflected in it, we become part of that conversation too, and that's a privilege. It's a connection to something larger than ourselves, something that extends through time, connecting past, present, and future generations in a shared quest for understanding, justice, and meaning. So when you think about medieval animal trials, don't just think about the strangeness, think also about the humanity, about people trying, caring, struggling with challenges we recognize, about lawyers defending the indefensible, about communities seeking justice, about rituals creating meaning, and let that connect you with them across all the centuries that separate us. Because in the end, we're not so different. We're all human, doing the best we can, trying to create a world that makes sense, that's fair, that has meaning. And this connection across time, across difference, across all the strangeness, is what makes history not just interesting, but transformative. It's what allows us to learn not just facts, but wisdom, not just about the past, but about ourselves. And as we approach the end of this journey through medieval animal trials, there's one last reflection to make. A reflection on what it really means to understand the past and how that understanding can change us in ways we might not have expected. There's a specific moment that happens when you really dive into history like this. A moment where something changes inside you. It's not just that you've learned new facts or gained new insights. It's something deeper. It's a shift in how you see the world, in how you see yourself, in how you understand what it means to be human. When the past changes the present, this change begins with strangeness. You encounter something, in this case animal trials, that's so different from everything you know that your first reaction is disbelief. This can't be real. People didn't do this. This is too absurd. But then you discover that yes, it was real. There are documents, court records, legal treatises, eyewitness accounts. It happened for centuries throughout Europe. Intelligent, educated, careful people did this and found it perfectly reasonable. And this creates a rupture in your understanding. If intelligent people could do something that seems so obviously absurd to us, then what else do you assume is obvious that might not be? What other beliefs do you have that future generations will find equally bizarre? This rupture is uncomfortable. It's easier to simply laugh at the past, feel superior, and move on. But if you stay with the discomfort, if you really try to understand, something interesting happens. You begin to see the contexts, the religious beliefs that made trying animals logical, the legal structures that supported it, the psychological and social needs it served. And slowly the absurdity begins to make sense. Not that you agree with it, but you understand how, within that context, it was reasonable. And this understanding changes something. Because if you can understand how intelligent people arrived at conclusions you think are wrong, then you have to consider that maybe you're also arriving at wrong conclusions that seem perfectly reasonable within your own context. This isn't relativism. It's not saying all beliefs are equally valid. It's recognizing that all of us, past, present, future, operate within frameworks of understanding that are partially constructed, partially limited, and that will inevitably change. And this recognition brings humility. A humility that isn't weakness but strength. Because it makes you more open to questioning your own assumptions, more willing to consider different perspectives, more aware that you might be wrong about things that seem obvious. But the change goes beyond humility. There's also an expansion of empathy. When you really try to understand those people trying animals, not just the facts of what they did, but why they did it, what they felt, what they hoped to achieve, you develop a capacity for empathy that extends beyond this specific case. You begin to apply the same empathetic curiosity to other situations. When you encounter practices that seem strange in other cultures, in other times, even in other communities within your own society, your first reaction is no longer immediate judgment. It's curiosity. What context makes this comprehensible? What needs does this serve? What can I learn from this? And this shift in how you approach difference is transformative. It opens possibilities for understanding that didn't exist before. It creates bridges where before there was only division. There's also a shift in how you understand change itself. Before studying something like animal trials, you might have thought about social change as something that happens through rational arguments. Someone proves a practice is wrong and then everyone stops doing it. But animal trials show that's not how it works. They didn't end because someone proved they were wrong. They ended because the world changed in multiple ways: scientific, philosophical, economic, social, until the practice simply no longer made sense. And understanding this changes how you think about changes you want to see in the world. If you want to change how we treat animals, how we deal with climate change, how we structure our economy, it's not enough just to argue that current practices are wrong. You need to work at multiple levels, changing economic structures, social norms, frameworks of understanding, to create a world where different practices make sense. This is harder than just arguing, but it's also more effective. And understanding this can make you more strategic, more patient, more effective in working for change. There's also a shift in how you understand justice. Before, you might have thought about justice mainly in practical terms: punishing the guilty, preventing future crimes, protecting the innocent. But animal trials reveal that justice also has psychological, social, ritual dimensions. It helps communities process trauma. It reaffirms shared values. It creates meaning from chaos. And recognizing these dimensions can make you wiser about how justice systems work, about why certain procedures that seem inefficient are actually important, about how to reform systems without losing the functions they serve. Stay with me until the end, because what comes next will surprise you, and there's a shift in how you relate to time. Before, past, present, and future might have seemed separate. The past is past, the present is now, the future is yet to come. But studying animal trials creates a sense of continuity. You see that the challenges those people faced, creating justice, dealing with the uncontrollable, living in community, are the same challenges you face. The tools have changed, but the struggles are the same, and this creates a connection across time. You're no longer alone facing unique challenges. You're part of a long, ongoing conversation where past generations struggled with similar questions, and future generations will continue struggling. And there's comfort in that, but also responsibility, because if you're part of this ongoing conversation, then what you do matters, not just for now, but for how the conversation will continue after you. There's also a shift in how you understand rationality. Before, you might have thought that being rational means applying logic correctly, and if you do that, you'll arrive at correct conclusions. But animal trials show that people can be perfectly rational, applying logic carefully, building sophisticated arguments, and still arrive at conclusions that are wrong because their premises are wrong. And this changes how you think about your own thought processes. It's not enough to be logical. You also need to examine your premises, question your assumptions, be open to the possibility that your fundamental frameworks of understanding might be limited or mistaken. And there's a shift in how you understand progress. Before, you might have thought about history as a straight line from primitive to advanced, from irrational to rational. But animal trials show it's more complicated. Those people weren't less intelligent than us. They simply lived in a different world with different frameworks of understanding. And we, with all our modern advantages, also have blind spots, also do things that will seem strange in the future. So progress isn't a straight line, it's a series of changes. Some progressive, some not, some ambiguous. And recognizing this makes you more humble about your own time, more careful in your claims of superiority. But perhaps the deepest change of all is in how you understand humanity. Before, you might have thought about humans mainly in terms of differences. Different cultures, different eras, different beliefs. But studying animal trials reveals deep similarities. The needs those people had for justice, for meaning, for control, for community are the same needs you have. The struggles they faced are the same struggles you face, and recognizing this shared humanity across all superficial differences is transformative, because it means you can connect with people across time, across culture, across belief. Not despite the differences, but through understanding what's shared beneath them, and this capacity for connection, to see humanity in unexpected places, to find common ground across differences, is perhaps the most important skill you can develop in a diverse and often divided world. So when you study medieval animal trials, really study them, not just learn facts, but try to understand, you're not just learning about the past, you're changing yourself, becoming more humble, more empathetic, more wise, more connected. And these changes spread. They affect how you interact with people who are different from you, how you think about complex problems, how you work for change, how you understand your place in the world and in time. They're not dramatic changes that happen all at once. They're subtle, gradual changes, but they're real. And they're lasting, and maybe that's what makes history, when done right, when approached with genuine curiosity and willingness to be changed, so powerful. It's not just about knowing the past, it's about being transformed by it. It's about becoming a different person, wiser, more capable of navigating the complexity of the world. Medieval animal trials are a door to this transformation. A strange door, certainly, but a real door. And if you're willing to walk through it, if you're willing to really engage with this history in all its strangeness and humanity, you'll emerge on the other side changed. Not because you now know facts about animal trials, but because you've developed capacities of empathy, of humility, of complex thinking, of connection across difference that are fundamental to navigating our complicated and wonderful world. And these capacities aren't just useful, they're essential. In an increasingly divided world, increasingly complex, increasingly challenging, we need people who can understand across differences, who can question their own assumptions, who can see humanity in unexpected places. Studying animal trials, really studying them with curiosity and openness, can help create these people, can help create you. And maybe that's the final and most important lesson. History isn't just about the past. It's about the present and the future. It's about who we are and who we can become. It's about transformation. And medieval animal trials, however strange they are, offer an opportunity for this transformation, an opportunity to become wiser, more empathetic, more human. All you need to do is be willing to really look, really try to understand, and let what you discover change you. And as we reach the end of this journey through medieval animal trials, there's one last reflection to make. A reflection on what we take with us when we leave this strange and fascinating history, and how it accompanies us as we move forward in our own lives. And so we reach the end of this journey through one of the strangest and most fascinating practices in human history. We began with pigs being hanged and locusts being excommunicated. We end with something much deeper, an understanding of ourselves, of our shared humanity across time, and of how the past can teach us to live better in the present, what we take with us. So what have we really learned from all this? What do we take with us when we leave this strange history of medieval animal trials? First, we take humility, the deep understanding that intelligent, careful, well-intentioned people can be completely wrong about things that seem obvious to them, and that we, with all our modern science and rational thinking, are probably also wrong about things that seem obvious to us. This isn't a humility that paralyzes us. It's a humility that frees us to question, to explore, to consider that maybe there are better ways of doing things than the ways we've always done them. Second, we take empathy, the ability to look at practices that seem strange or even absurd and ask, what context makes this comprehensible? What needs does this serve? What can I learn from this? This empathy doesn't mean accepting everything uncritically. It means understanding before judging. It means recognizing humanity even in unexpected places. And in a world as divided as ours, this capacity for empathy across differences is precious beyond measure. Third, we take a deeper understanding of justice. That justice isn't just about logic and efficiency. It's also about ritual, about meaning, about helping communities process trauma and reaffirm shared values. And this understanding can make us wiser about how we create and reform justice systems. It can help us see that procedures that seem unnecessary might actually serve important functions. It can remind us that justice is as much about how we do things as what we do. Fourth, we take an appreciation for the complexity of change. That real change doesn't happen through simple rational arguments, but through transformations at multiple levels: economic, social, cultural, intellectual. And this understanding can make us more effective in working for changes we want to see. It can make us more strategic, more patient, more capable of working at multiple levels simultaneously. Fifth, we take a sense of continuity across time. That the challenges we face, creating justice, dealing with the uncontrollable, living in community, are the same challenges humans have always faced. And this continuity is both comforting and empowering. Comforting because it means we're not alone, that there's accumulated wisdom from generations we can access. Empowering because it means what we do matters not just for now, but for how the human conversation will continue after us. Sixth, we take a more nuanced understanding of rationality. That being rational isn't enough if your premises are wrong. That you need to constantly examine your fundamental assumptions, question what seems obvious, be open to the possibility that your frameworks of understanding are limited. And this understanding can make us more careful thinkers, more open, more capable of really learning and changing. Seventh, we take an appreciation for the power of ritual. That rituals, legal, social, religious, aren't just empty formalities. They serve important functions, they create meaning, unite communities, help process experiences, reaffirm values. And this appreciation can make us more careful about which rituals we preserve and which we abandon, more aware that efficiency isn't the only value that matters. Eighth, we take a deeper understanding of the line between humans and non-humans. That this line is more complicated than it seems, that questions about agency, responsibility, and rights of non-human beings are ancient and ongoing. And this understanding is relevant to modern debates about animal rights, about AI, about how our legal system should deal with entities that have some kind of agency but aren't human. Ninth, we take an enhanced capacity to see humanity in unexpected places, to recognize that people very different from us, in time, in culture, in belief, still share fundamental needs, still struggle with similar challenges, still deserve empathy and understanding. And this capacity is essential for navigating our diverse and globalized world, for building bridges across differences, for finding common ground even amid deep divisions. And 10th, we take an understanding that history isn't just about the past. It's about the present and the future. It's about who we are and who we can become. It's about transformation. Studying medieval animal trials isn't an abstract academic exercise. It's an opportunity for personal growth, for developing capacities that are fundamental to living well in a complex world. But beyond these specific lessons, there's something more we take. Something harder to articulate, but perhaps more important. It's a sense of wonder at human creativity, at our capacity to create elaborate systems, to apply intelligence to impossible problems, to seek meaning and order even when the world seems chaotic. It's a sense of connection with those people across the centuries, with their efforts and struggles, with their humanity shared with us. It's a sense of perspective on our own time, on our own challenges, on our own place in the long human conversation through history. And it's a sense of possibility that we can learn, change, grow, that we're not stuck in our current ways of thinking and doing, that there's always more to discover, more to understand, more ways of being. These senses, wonder, connection, perspective, possibility, are perhaps the most valuable gift history can give us, because they change us in ways that go beyond specific knowledge. They make us different people, wiser, more open, more human. And when you leave this history of medieval animal trials, when you return to your everyday life, these changes come with you. They affect how you see the world, how you interact with people, how you think about problems, how you imagine possibilities. You might find yourself more patient with people who think differently from you, more curious about practices that seem strange, more willing to question your own assumptions. You might find yourself thinking more complexly about problems, seeing multiple sides, recognizing nuances you didn't see before. You might find yourself feeling more connected with the past, with people different from you, with the long human history of struggle and trying and creating meaning. And these changes, however subtle, matter. They make you a better person, more capable of navigating our complex world, more capable of contributing to important conversations, more capable of making a difference. So when you think about medieval animal trials, don't just think about hanged pigs and excommunicated locusts. Think about what this strange and fascinating history can teach you about humility, about empathy, about justice, about change, about humanity. And let these lessons change you. Let them make you wiser, more open, more connected. Let them be part of how you live your life, how you interact with the world, how you contribute to the long human conversation. Because in the end, that's what history really is. Not just facts about the past, but an ongoing conversation across time where each generation learns from the previous ones and contributes to future ones. Medieval animal trials are part of that conversation, a strange part certainly, but a real and valuable part. And by engaging with this history, by trying to understand it, by letting it change us, we become part of that conversation too. And that's an honor. It's a privilege. It's a responsibility. So as you move forward back into your life, take these lessons with you. Take the humility, the empathy, the understanding, the connection. Let them inform how you live, how you think, how you act. And perhaps when you encounter something that seems strange or absurd, whether in the past, in another culture, or even in your own society, you'll pause. You'll remember those lawyers defending rats, those judges pondering the culpability of pigs, those communities seeking justice in the only way they knew how. And instead of laughing or judging immediately, you'll ask, what context makes this comprehensible? What needs does this serve? What can I learn from this? How does this connect me to the shared humanity that unites all of us across all our differences? And by asking these questions, by seeking understanding instead of judgment, by recognizing humanity in unexpected places, you'll be honoring not just those people of the past, but also the best of our shared humanity. You'll be contributing to a world where differences are bridges to understanding instead of walls of division, where curiosity overcomes judgment, where empathy overcomes prejudice, where we recognize that all of us, past, present, future, are doing the best we can with the tools and understandings we have, and that's a world worth fighting for. A world that needs people who have learned the lessons history has to teach. People like you who have been willing to dive into a strange story of tried pigs and excommunicated locusts, and who have emerged on the other side changed, wiser, more human. So thank you for taking this journey. Thank you for being willing to look beyond the surface absurdity to find the deep humanity beneath. Thank you for letting the past change you, for carrying these lessons forward, for becoming part of the ongoing conversation that is human history. And as you move forward, remember, you're not just carrying knowledge about medieval animal trials, you're carrying wisdom about humanity, about justice, about change, about connection across difference. Use this wisdom well. Let it guide you. Let it make you a force for understanding, for empathy, for justice, for humanity in a world that desperately needs these things. Because in the end, that's what really matters. Not the specific facts you learned, but the person you became by learning them. Not the knowledge you gained, but the wisdom you developed. Not the history you studied, but how that history changed you and, through you, the world. And that's the true magic of history. That's the true lesson of medieval animal trials. That's the true reason why strange stories of hanged pigs and excommunicated locusts still matter centuries later, because they remind us of our humanity. They connect us across time. They teach us to see beyond superficial differences, to recognize the shared humanity that unites all of us. And in a world that often seems divided beyond repair, that's a lesson we need more than ever. So take it with you, live it, share it, and let it make a difference, because you can, and because the world needs you too. Good night, and may your own journeys be filled with discovery, understanding, and deep human connection.